The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Be seated. Good morning. Welcome to the Court of Appeals. Judge Diaz and Judge Quattlebaum and myself, Judge Wynn. We will start with the first case today. We have 4 cases. First case will be Geiger versus the Zurich American Insurance Company case. And we will hear from Counsel Bax. Did I pronounce it right?
It's actually Box, but nobody gets that right, so I'll answer to either, sir.
Well, it's because it's spelled B-A-X, not B-O-X.
Correct. May it please the court. Good morning, Your Honors. My name is Nathan Box, and I'm with the Foster Law Firm in Greenville, South Carolina. And I'm here today on behalf of the appellant, Kevin Geiger. I'm honored to appear before this court again. Your Honors, I'm going to do my best to expound upon specific points and not just repeat what I've already stated in my brief. So first, I would like to comment briefly upon the abuse of discretion standard of review before I turn to the district court's opinion and the own occupation definition of disability. Now, Geiger fully recognizes that the abuse of discretion standard of review is very deferential. However, I would respectfully submit that the standard is so deferential only because the burden put upon plan administrators is so great.
So when you say the standard of review and the abuse of discretion, usually we're talking about a district court or a judge here. Where is your direction here?
Your Honor, because I believe that the district court, in its review, accepted a lot of the factual statements made by Zurich in its argument without doing a thorough analysis of their review, looking for the reasonableness within that decision.
So your focus is not on the abuse of discretion by Zurich, but the abuse of discretion by the district court?
Well, Your Honor, I believe that the district court misapplied the abuse of discretion and accepted factual conclusions asserted in Zurich's final denial letter without analyzing whether or not there was evidence within the record to back up those conclusions. And we don't believe that the record had the evidence and the analysis needed for Zurich to reach the denial that it did, which led to its abuse of discretion, and the district court failed to review that adequately. Thank you, Your Honor. Going on with that point, Your Honor, I believe that the deferential standard...
Before you go on, so I thought I heard you say that you didn't think the record had sufficient evidence to support the insurance company's findings and by implication the district court's affirmance of those findings. But whose burden is it to present evidence in this case?
Your Honor, I believe that it is the claimant's burden to provide all the factual evidence of the case, the medical records, doctor's opinions, statements from him.
I agree with you. So if that's the case, and if you're saying that there wasn't enough evidence in the record, then that's on you, right?
Well, I believe the evidence that's lacking here is how Zurich applied the own occupation definition of disability. Now,
well, that's not evidence. That's a sort of an application of a standard.
Yes, Your Honor, but there is generally within these records vocational analysis, which I'm calling evidence, but there's opinions of qualified individuals about the own occupation and how it's performed in the national economy. And we don't have any of that analysis here, and that's where I believe the abuse of discretion lies, Your Honor.
So what we have, it seems like, is Zurich relied on information from treating physicians that despite his heart problems and heart procedures, he was walking and doing things that would, they found, the administrator found, allow you to do a sedentary job, and then they had a peer-reviewed doctor talk to the treating physicians, assess the medical records, and come to that conclusion. Yeah, I can appreciate disagreeing with that conclusion, but why is the process that it uses the information from the treating physicians not evidence that would be under the standard review enough to affirm?
Your Honor, I believe that the issue here is that the plan defines own occupation as how it's defined in the national economy.
Right.
And Zurich asserts that his occupation is sedentary, but we don't have any vocational review or evidence in the record that his job as it's performed in the national economy is sedentary.
Well, he doesn't challenge that, really. It sounds to me, I thought his objection was not that his job involved some sort of very physically active work, but the actual job he did involved unusual hours and maybe high stress. But that's different than whether it's sedentary or not. It's that in that particular application, may have been sedentary, but it was just irregular and maybe not the sort of thing that is, works great for him.
Yes, Your Honor, I completely agree with that because we don't, we believe it probably is sedentary. I believe that the job would, is what he did for CBS News is likely, we believe, very typical to what a news editor would do at any location in the country.
What are you agreeing with?
That
Agreeing that this is a question in terms of whether the job is sedentary and whether the evidence meets that?
Your Honor,
Because you seem to be making an argument, and I'm just following up on Judge Baldwin, I'm not trying to get into it, but you seem to make an argument about the stress from the mental acuity, but where is that evidence that connects that here that you presented? To return to Judge Diaz's question, the evidence is for you to present, yet what you have is a doctor who says, well, your claimant could walk 3 miles a day.
yes, Your Honor.
And his job is sitting down at a news, I guess, editor-type position during the day. But the evidence of the mental acuity, where is that?
Your Honor, and we believe that we submitted evidence of what his job is. And like you said, it's odd hours, high-speed work, his ability to work, over hours if there's a breaking news situation and stay at his desk until the next editor. All these things create a job where just generalizing it as a sedentary occupation, the broadest physical definition of that occupation misses the point of the own occupation definition of disability in the plan.
But it's the risk factor that is at issue here. The risk, he has this condition, and yes, this job is this in terms of stress, but we got it in terms of the physical side of it, because there's evidence from the other side he can do all these things, and so it's sedentary. But what connects the heart conditions and all of that to the mental side of it?
Yes, Your Honor.
Other than it exists. It is a job that's mentally challenging or whatever, but there's nothing here in terms of the evidence you presented that connects that.
Yes, Your Honor, I do, Dr. Izzo, his treating physician in North Carolina, and I do acknowledge that I wish he had more explicitly stated this, but he repeatedly said that his clinical status is always tenuous, and that's the reason why he believes he's disabled. And we believe that that's a clear designation that we have to look beyond just what his active symptomology is when he's home and not working, and instead look at, would returning to his occupation exacerbate his medical conditions? And Dr. Cole, his cardiologist in New York, told him that if he returned to work, he would be back in for open heart surgery within a year. And I believe that that's the clear evidence that demonstrates that, yes, he may be doing fine when he's home and not working. Yes, he can watch TV at home and read books for pleasure, but that is not the same as returning to work in, a high stressful environment, particularly for a long-standing cardiac patient, Your Honor.
To follow up on that, reading the records, it seems like the disability that they talk to is the physical cardiac, his heart problems. And as I read the tenuous language, it was referring back to his recent heart procedures. And so if he had been disabled related to, mental health related issues, which certainly can happen, but I don't think he was. And I don't recall a doctor saying he was. So if he wasn't disabled for that reason, but was disabled for physical reasons, and and then there's evidence that his physical reasons have improved, how do we add something that wasn't part of the reason he was disabled for?
I believe, Your Honor, that yes, he is mentally sharp. We're not saying that he is cognitively unable to do any portion of his occupation, but instead the high-paced nature of his job, all of those would exacerbate the physical conditions, which would reappear very quickly. So I believe it's the mental aspect of the job that would affect his physical conditions and prevent him from returning to that occupation and being able to perform it in a continuous manner. Thank you, Your Honors. Let me continue on.
Is your only argument that Zurich failed to consider the mental acuity and the stress of the position?
Yes, Your Honor, and the district court said that high mental acuity and odd hours do not create material and substantial duties, and we believe that's a misinterpretation of the terms of the plan. The terms of the plan state that it has to be the duties that he is required to do, and that cannot be reasonably omitted from that job, but for, working an average of over 40 hours. Now, under that definition of material and substantial duties, working odd hours, high mental acuity, high stress, do qualify as material and substantial duties. And I believe, Your Honor, without, a vocational analysis of how it's performed in the national economy, I believe that those would be found to be material and substantial duties of any breaking news editor in the country.
Well, stress isn't a duty, it's a consequence of the work, right? And it may be different for different people. And I guess I could go back to the concern we have about the medical evidence in this record, which you forthrightly, and we appreciate, conceded could have been better. The sort of statement that his condition was tenuous, what does that mean in this context?
Your Honor, I believe that when Dr. Izzo made those statements, he always, relayed the extensive cardiac history and the number of the 5 surgeries that he'd had and the number of valve replacements. So I believe that the evidence viewed objectively would demonstrate that when the doctor says tenuous, he means that his condition could worsen very easily. And particularly him saying that the reason he's disabled is because of his tenuous clinical status would mean that a return to work would cause an exacerbation of his symptoms, a decline in his condition, and that is the reason he's unable to work.
What do we make of his statement that, or at least your colleague's statement on the other side in the record, that their expert, Dr. Sims, then went back to Dr. Izzo and asked him about whether he could work full-time, and he said he did not seem to disagree that Geiger, your client, was capable of full-time work. What does that mean?
Yes, Your Honor. I don't believe that the reviewing physician stating that is very clear and reliable and probative evidence. Dr. Izzo, throughout the record, has been nothing but very supportive and has put it in writing multiple times, including some claims notes where he had his nurse return the call and make a statement. And so the reviewing physician repeating that, he may have gotten that impression, but if they wanted to make that reliable evidence, they should have sent it to Dr. Izzo for his review and signature, which is a common practice amongst these claims. Your Honors, unless there's any more questions, I'm out of time, so I appreciate your time and consideration.
All right, you have a few minutes in rebuttal. We'll hear from Ms. Solares.
Good morning. May it please the court. Irma Solares on behalf of Appali, Zurich American Life Insurance Company of New York. As this court has properly observed, the key question here is whether Zurich failed to consider the stress or mental acuity, the impact that that could have had on his position. And I submit to the court that it did not, because that was never an issue in the administrative record. That didn't come up. The record is very clear that during the 15 months that Mr. Geiger was under treatment by his physicians and receiving disability payments, both short-term disability and long-term disability, those physicians submitted on multiple occasions extensive medical notes and records to Zurich. In addition, we have 3 attending physician statements from Dr. Cole in New York. We have 2 attending physician statements from Dr. Izzo in North Carolina. And not a single one of those referenced stress or his inability to perform his job because of lack of mental acuity. In fact, there's nothing in the 746-page record that brings stress to the forefront.
Well, let's think about it. We all can agree, if you look at this medical testimony and evidence here, that Mr. Geiger surely has a serious heart problem.
Yes.
He's had multiple procedures and all kinds of heart ailments. To what extent can we rely upon just common sense that stress is not good for someone with any heart problem, but surely not with the very serious nature of his heart problems?
Well, Zurich has to rest its decision on substantial evidence. A finding of disability is based on substantial evidence. And the substantial evidence here was the medical records. It was the statement of job duties submitted by CBS. It was the resource questionnaire submitted by Mr. Geiger, which made no mention of stress or inability to perform any of his functions.
Was Zurich required to consider Dr. Izzo's statement, this always tenuous language? What did he mean by that? And were they required to consider that as maybe pulling in this stress business?
Well, it required, Zurich certainly considered Dr. Izzo's statement and followed up with him and spoke with him. And as the court acknowledged, as the panel acknowledged, he thought he could return to work. And that's not inconsistent with what the record shows. In fact, Dr. Cole, a month after the surgery, believed that Mr. Geiger could return to work by February of 2019. Dr. Izzo first sees Mr. Geiger in April of 2019 and right off the bat says he can't work, even though he's just seeing him. So the statement about his tenuous condition, I don't think can translate to stress. I think there has to be greater specificity in the record for that to have been an issue for Zurich to consider. I don't think it could have simply insinuated from tenuous condition that he was under a lot of stress or that returning to a stressful position, which he didn't know. Nobody knew that whether it was stressful or not stressful.
Let me ask you, I take it Mr. Geiger actually retired from CBS News.
Correct.
And in terms of insurance of long-term disability, which has been denied here, is he in a position that if something were to support that now, he still would be covered for that? In other words, is that the end of it? If he is now denied and now he's retired, he no longer will ever be eligible to get that type of, just because he's not working. Is that the case?
Well, I think we have to reframe it in the sense that the terms of the policy that we're considering here is the first 24 months, which is own occupation, whether he was able to return to work to his own occupation. After the expiration of 24 months, then you look to any occupation. That would be a different analysis going forward.
You're probably not going to find one more sedentary than this one, where the employer said it was 89%.
What about this
Correct.
one?
Now, Judge. You're about to become chief, so be careful.
Correct. His profession is journalism, and so I think that's a question for another day, whether what would happen under any occupation consideration. But under own occupation, it's whether, correct, he's retired, what would happen now?
But I ask because this chief evidence that seems to be missing is the whole business on the mental acuity and the connection to stress in the job.
Correct.
It seems like a doctor could go there if someone had just asked them to do it, but it wasn't done. I'm not sure they would. But my question is, if that happened, is that in a posture to change the nature of this case? I'm not trying to make a case for him to do so. I'm just saying, just interested in where this case is and what does it mean to deny it at this point and then bring it up on appeal and then get that upheld. Does it just keep going on and on?
Correct. I mean, I think we have to look back to when Zurich made that determination, and it wasn't part of the record. Were it to go back, which we hope that would not be the case, and it were raised, that's a different issue for a different day. But on the record before the court today, it wasn't raised timely. It was raised belatedly by counsel in the litigation, but it wasn't part of the administrative record. In fact, one of the documents that was completed by Dr. Cole, a functional work assessment form, has a section for stress. And he wrote in NA, not applicable. But it asks a series of questions regarding whether stress, ability to function under stress. And that was simply not completed. So I think on this record, there was nothing for Zurich or the district court to conclude that stress was a factor or that he lacked mental acuity to perform his job functions.
Can I go back to the point that Judge Wynn was making about how this does seem to make some intuitive sense? You've got somebody who's got a history of cardiac conditions, and I think a reasonable person might conclude that any job with any level of stress might not be ideal for that person. Then on top of that, you have Dr. Izzo, who probably could have and should have said more, but at least on one or more occasions said that Mr. Geiger cannot work. And then on top of that, you have your doctor, Dr. Sims, who never really examined Geiger and nonetheless came to a conclusion that he could work, which seems to cut against the validity of his opinion, or at least perhaps question it if you haven't taken the time to actually examine somebody. So what about all of that? If you take all of that, doesn't that raise a question?
I don't believe so. I think you do look to the substantial evidence that's in the record. And the least substantial thing in the record was any inference of stress or inability to perform the position because of, mental issues or those issues. Yes, Dr. Izzo, all he said was cannot work. But Dr. Sims looked at Dr. Cole's medical records, Dr. Weinberg's medical records, Dr. Izzo's medical records. It looked at the form completed by Dr. Cole where he opined that he thought granted it was a month after surgery, but he thought that Mr. Geiger could return to work. And the reality of this record is that after his surgery and after Dr. Cole completed that form, Mr. Geiger continued to improve. He went into surgery 60 pounds heavier. By April of the following year, he was 60 pounds lighter. He was doing well. He was walking, 3 miles a day. Dr. Sims also took into account his echocardiogram that was done in April of 2019, which came back perfect. If one looks at the medical records and really analyzes, Mr. Geiger's only complaint was discomfort after long walks.
If we are looking strictly at the physical capabilities of doing it, and we consider the evidence that seems to be so strong here, the loss of 60 pounds, walking 3 miles a day, which some seems to be walking a dog, maybe 2 or 3 times a week. Being a news editor at CBS with the kind of job that he has is not the same as walking a dog. When you are relaxed and you're walking through the neighborhood, your dog, your biggest problem is he going barking or whatever. It just seems that something else ought to be considered in saying you can go back to work based upon the fact that and by the way, he was doing this, he really was trying to improve himself, which to some extent, a lot of it is his own statements, I'm sure. And I don't know what the message comes from this for the next case. That someone goes to a doctor, you don't tell that doctor you've been walking 3 miles a day if you want long-term disability, and you don't tell those things. But even though he can do that, the question is, why is it that Zurich wouldn't at least go into some functionality type test or something, or requirement, because just intuitively, being a news editor for CBS doesn't sound like to me it's an easy job, and I could see the stress because the nature of news coming across, but walking a dog in your neighborhood is not the same.
It's not the same, admittedly, but his job duties, Zurich did take into consideration his job duties, which were writing news copy, and it looked at the physical demands of the job, and it's 89% sitting, standing on occasion, lifting less than 10 pounds.
That much we agree in terms, if you're looking at sedentary, maybe that's where Judge Diaz is going with our job. We sit a lot. And if that's what you mean, but when you're sitting and you're dealing with high-stress topics of news stories, of all kind of input and stuff, why is that not something it has to be if you got to go back to, with a heart condition, and not just an ordinary heart condition. You could rattle off what Mr. Geiger has in some of those conditions. I didn't know one person could actually have all of them. But he is no question about that. You have to at least believe there's got to be some connection.
Well, I think that really is shifting the burden here. Whose burden is it to raise these issues? Is it Zurich to volunteer these things, to knock on Mr. Geiger's door and say, are you sure you're not too stressed? Are you sure you can, do this? It was his burden to come forward with evidence that he was not able to perform the material and substantial duties of his position because of the added stress it would cause, or because he lacked mental acuity to focus. That's not on Zurich. Zurich, any insurer shouldn't have to anticipate the claimant's arguments or presume their mental condition.
I'm thinking of a job like an air traffic controller. That if you had the same kind of evidence up there and no one mentioned the stress of it, but you got a heart condition like him, your point is, even then you need an expert to come in and connect and say, this stress is problematic here because and it affects his mental acuity because he has this heart condition. He could talk about the oxygen going through his body, that sort of stuff. You're saying that's lacking, and we should hold him to present that. That's why I present the other question. It seems evident to me, maybe I'm wrong on it, and maybe they can't, that all he has to do is go back to a doctor and really get a doctor to examine him and come back with that kind of statement. But the doctors here seems to have been focusing on the physical side only. And that's where you think we should draw the line and hold him to the burden that if he has this, don't just use common sense to do it. Make him prove it with expert testimony.
Yes, I agree with that. I do think that is my position. Not just expert testimony, but something in the record. Zurich's,
Counsel isn't, go ahead and finish your answer, I'll follow up.
Pardon me.
No, you finish.
Zurich's obligation is to make the determination of disability based on substantial evidence. And where there's an absence of evidence, here, stress was not a fact. It's the absence of fact. And
Is it, that was my point, isn't it a little bit more than the absence of fact? I mean, I think Judge Wynn and Judge Diaz make, very, good thoughts about, is there just some obvious connection of stress to someone who's suffering from heart problems? And while that may be truth, it seems there's not only the fact that the doctors don't mention stress, the functionality documentation from Dr. Cole almost suggests the alternative. Now, I don't know why he would say not applicable. I'm not a doctor, but in the record, it's not just an absence of any discussion about stress. There's in the record places where that could have been talked about and it was affirmatively marked as not applicable.
that's correct.
If I understand it, is that right?
That is correct. That is correct.
And that may be hard to kind of really understand just from us sitting here now, but that's part of the record that Zurich had to look at, as I understand it.
That is correct. It was a 746-page record, and there's nothing from any physician or any kind of credible evidence that, stress was a factor. And it wasn't Zurich's obligation to raise stress or to suggest that perhaps he might be stressed or couldn't perform his job functions because of that. Unless the panel has any further questions, Zurich will rest.
Thank you very much.
Thank you.
Mr. Box.
Thank you, Your Honor. Just a few quick points.
Before you do,
Yes.
you heard the statement she just made?
Yes.
There is nothing in the record that would indicate from any physician that stress was a factor. Can you
Yes, Your Honor.
confirm that?
I do. They're not explicitly using the word stress, and I agree with that.
So we can agree there is nothing explicitly, meaning no plain statement from a doctor or anyone indicating that stress was a factor. So to get there, how do we get there? By implication or what?
Yes, Your Honor, I do think it is implicit, and it's also common sense. When asked why he couldn't return to work, this is in a claims note when Geiger was speaking to one of the representatives.
Why rely on common sense? Why not just, why didn't you just get the doctor to opine or give his opinion on that? I mean, where are we going to go with this common sense thing when we're dealing with issues of this sort? And it really comes to the question of when was it known that this is not enough?
Yes, Your Honor. Unfortunately, how these cases go, the claimant doesn't know until they get the final denial. And that's sort of the unfortunate nature of how these cases go. Zurich has the final denial, the final say in it. The CFR has changed since this case was enacted, where the final opinion is sent to the claimant and they have a final chance to review. That was after this case occurred. So unfortunately, the plaintiff or the claimant can think that their evidence is sufficient, can see something that they believe is very obvious, and then after they receive the final denial letter, find out that it's not. But, Your Honor, I would say that Geiger stated to Zurich, and I'm paraphrasing, but he said something along the lines of, they asked him, why couldn't you go back to work? And he said, it's the odd hours and going from 0 to 100 million miles an hour. That's stress, Your Honor. He didn't use the word, but I think that anybody reading that would understand that it's the fast-paced nature of his job, that as a cardiac patient, he simply wouldn't be able to do without risking his life and health.
You really making some good points. It's close, but the question then becomes, how do we deal with this on appeal? You heard Judge Qualibon's question in terms of what this all means, but, and I agree, 0 to 100 miles an hour, he's obviously not talking about running or doing anything physically in
Yes,
that
sir.
position. He has to be talking about mentally or something there, because CBS says his job is 89% sedentary. So, these are difficult cases because we rely upon enforcing burdens here. And the burden here is to present that evidence, and when one does not present it, particularly from an expert on this, and even though we know these things to be true, or it's common sense, the only reason we know it is because maybe personal experience or physical, but the medical side of it, a doctor should be able to see it. If it's that much common sense, then the doctor should be able to just verify it, and sometimes they may not like to say stuff that's common sense. But in this instance, you kind of need it, don't you?
Yes, Your Honor, and I believe that the burden is on the plaintiff to provide the evidence, but the burden is also on the defendant to do a thorough analysis. And if they see that that's an obvious question, a common sense question, their peer review could have asked that, or they could have had a second peer review. Every doctor that saw Geiger in person said that he was disabled. The only person disagreeing is the peer reviewer, which did not see him in person. Zurich has the ability under the terms of the plan to send him for an IME, an in-person medical exam, or send him for an FCE, a functional capacity exam. Those are rights that they have under the terms of the plan, and they failed to do so.
Counsel, one thing that strikes me as as we think about this case, and this certainly isn't to suggest there weren't elements of meaningful stress in the job, but I guess the argument could be made. Lots of jobs have at times elements of stress. Almost lots of them do. And perhaps we should be maybe the reason there's not something in there, I'm just speculating here, which probably isn't that good of an idea to do, is, the argument almost would be that anyone has the cardiac conditions that, like your client had, that they would be permanently disabled because maybe this is on the high end of stress, maybe it's on the medium end of stress. Your job's pretty stressful, I'm sure, and people come back and do that. So, perhaps the absence of evidence is not to say there's no stress or can never be connections, but the doctors were aware that a lot of jobs have some stress, and the primary issue here is physical.
Yes, Your Honor, and I believe that the court does not need to draw any bright line rule on this. It is a question of every person's cardiac issues or whatever are going to deal with stress differently.
Right.
And I think that we do have a situation here where the record raised the issue implicitly, but with the burden of analysis on Zurich, the court does not have to find that there's enough evidence in the record. It can inherently remand the case and say, this is a question that was raised. We're going to send it back to the insurer with instructions to do an FCE, do an IME, address these issues, Your Honor. And so we believe that it is a question that is difficult. I do see I'm out of time, Your Honors. Any further questions?
Thank you.
Thank you, Mr. Fox. Thank you, Ms. Solaris. We will come down and greet counsel and proceed to the next case.
It's perfect.
All right, we'll proceed with the next case, which is the Gerthy versus PHH Mortgage Corporation. All right, counsel, if you're ready to proceed, we will hear from Mr. Buckmiller first.
May it please the court, Your Honor, Matt Buckmiller from Buckmiller, Boyette and Frost Law Firm. With me is my partner, Blake Boyette. There are four fundamental issues that are for the court to consider today. The first predominant issue for the court is whether the bankruptcy code preempts plaintiff's state law claims. Said another way is whether a person that has filed bankruptcy and received a discharge in bankruptcy should have different or less rights than a person who has not. The district court granted summary judgment to the defendant, PHH, on all claims. It found that plaintiff's claims for violations of the North Carolina Debt Collection Act, as well as the intentional infliction of emotional distress, and NIED claims were preempted by the bankruptcy code. That is.
Can I stop you right there just to make sure I understand how you're framing that preemption issue? You've referred to the discharge provision, which suggests you're talking about post-discharge conduct by the defendants. Is your arguments about post-discharge conduct only or pre-discharge conduct?
It's a good question, Your Honor. We believe that it is both pre-discharge and post-discharge, but what I'm predominantly going to focus on today is post-discharge.
How is it possible that it's pre? I thought all this happened after the discharge.
No, Your Honor. So, and I'll just maybe get into the facts a little bit, and that will help facilitate a discussion of this. The point of the bankruptcy is a fresh start. The debtor filed a Chapter 13 plan in which the automatic stay automatically goes into effect, which prohibits a creditor from trying to collect or do anything with respect to.
So the differentiation is between when the automatic stay goes in and the actual discharge.
Yes, Your Honor.
We're talking discharge here.
After the discharge, Your Honor, there were numerous calls and attempts to collect on a debt that was not owed.
The discharge is like an order.
The discharge is an order. Your Honor, just a minute here.
Follow me.
Okay.
We're going to let you get there.
Yeah.
I just make sure I understand it.
Yes, sir.
You tell me if I'm wrong on it.
The discharge is an order.
It is enforceable by contempt.
Yes, sir.
Is automatic stay enforceable by contempt?
It is enforceable by a specific private or statute.
But it's not enforceable by contempt.
I've not seen it enforceable by contempt because there's a specific statute that delineates when you can use it. And
Violation of automatic stay tells you, you do that, you're really in trouble because the statute tells you what's going to happen. When it comes to a discharge, then the question is, whoever's doing it can be held in contempt.
Correct. And except, and this is what our case is about, is for recovering for violations of the North Carolina Debt Collection Act post-discharge. So we have a situation where after discharge, the debtor has no further obligation to the creditor whatsoever. That's the point of the discharge. That's the point of the bankruptcy, is to get a fresh start. And in this instance, after the debtor received his discharge.
Here because he's got a house with his wife's name on it too, and she is not part of the bankruptcy proceeding.
Correct. She is not part of the bankruptcy, and their divorce was in 2011, which was 5 years before the actual discharge.
Thing I've ever heard in terms of how that would occur. Now, his name remained on the house even though he's suspended from the real property. So he is still in joint ownership with the wife, with the ex-wife.
Yeah, until there is a foreclosure, then he remains.
Title is entitled, both of them, and now it's Tennessee in common because they're no longer married.
That's correct.
So he's got a house at Tennessee Common. There's a debt on that house. She's not discharged from it. He is on it. The debt collectors then send notices out, I guess, to the name there, wherever it goes to him. It puts him on it because he's still on this title, and he rightly says, you shouldn't do that because I don't owe this debt on it. And then they got a disclaimer on this note that says if you've been out of bankruptcy, then you don't have to worry about this. But the credit company, credit agencies and others don't pay that any attention, you say. It's an odd case. I don't know how we get here on this. I looked at it and see, this guy, is he still in the Marine Corps?
Yes.
I should have Judge Diaz, you may be recused from here, Judge. No, I know it will not affect that, because I'm Navy.
With any luck, I would be, but
But, so now he's coming to us, no one's asked him to pay anything. The other companies, they recognize he's discharged, but he now seeks some relief because he has all these negative things that have happened to him because they sending him these debt notices.
Your Honor, I think that's generally correct. So after the discharge, PHH and its predecessor, Ocwen, continued to collect on the debt, and they did that via mortgage statements.
well, that's not entirely accurate because your client, even though the debt was discharged, he surrendered the property. He still had obligations with respect to the property, at least with respect to expenses and maintenance of the same. So when you say the creditor and your client were done with each other, that's not entirely accurate, right?
Well, no, Your Honor, I think it is accurate, and I think what you're referring to is the Henry Rose case, which talks about, in essence, what happens when a debtor surrenders his property. And what the court in that case said, in which they've extrapolated, I think, to something that's incorrect, is that a bank or a creditor has no obligation when a property is surrendered to take the deed. And they can do that for various reasons, such as they don't want to pay the property taxes, they don't want to pay the HOA dues, they don't want to maintain the property. Henry Rose does not stand for the proposition that a creditor can then, after a discharge, selectively decide which expenses it wants to pay relating to a property expense and then charge those amounts to the debtor. The relationship and the discharge provides that there is no further amount that this creditor can charge this debtor. Now, the debtor, since he is the owner, could still be responsible for property taxes or things like that where he is legally required to pay them. But Henry Rose does not stand for the proposition that a creditor can charge a debtor for property, whatever they think the property-related expenses are. It's solely saying, and it's in rem versus in personam. Here are the remedies with the property. Since the debtor is still owner of the property, he can be obligated to pay the taxes. Normally, the creditor will pay the taxes because they want to reserve their lien rights and they don't want the taxing authority to foreclose. But that case does not stand for the proposition that a creditor can go in, charge whatever fees they want after a discharge, and then try and collect those fees against them.
What does it mean to surrender the property in this context? It means he just left the property.
It means two things. Surrender the property means that under the plan, that he has no further obligations to make any payments once the discharge is entered, once all of the payments pursuant to his Chapter 13 plan. And then, factually speaking, he also did leave the property. So the property has been vacant for...
That's what I'm trying to get at. What does it mean? I mean, what does it mean legally to surrender the property? If you would just ask the average person on the street, he says, well, you just gave up the title to it. He didn't. He still owns the property. He surrendered the property, but his wife still is owner of it. Could he go back and live in this property?
I assume, Your Honor, that he could. I don't know why a bank would not foreclose, which is what they would have to do. Simply giving them
You could go back and just pay the mortgage on it, and you wouldn't foreclose. I'm just understanding what it means to do it. If he goes back to live in it, his wife is one-half owner of it. Debt is still on the property, because wife is still on it right now. Now, I don't know if it goes on one half or how does it all work on it. But it's really an intriguing case to me, the way bankruptcy and real estate law is working out here.
Well, I will say, Your Honor, is that if the facts were that the creditor was only trying to collect on those debts, then that would be an important distinction for the court to have. In this case, the creditor was seeking to collect on the full amount of the debt the whole time, meaning they took no steps after the discharge.
Okay, so I'm glad you raised that, and I don't want to get distracted by this, but if they had done what you suggested, that is simply sent a bill for the expenses related to the upkeep, taxes, whatever, you wouldn't have a claim, would you?
Well, Your Honor, we're saying that they have no ability to send those bills to us because Henry Rose does not allow them to charge any post-discharge expenses to our client.
Well, how are they supposed to get paid then?
They foreclose. That's the in rem versus in personam difference, is that all their remedies are tied to the property. None of them are tied to the person.
Okay.
And so if Onslow County Taxing Authority submitted a bill and Mr. Guthrie didn't pay it, they could sue him for that. But that's a direct relationship between Mr. Guthrie and the taxing authority. There's no intermediary. And I will also say that.
To me, that someone should have had the husband to transfer his interest over to the wife, which is typically what happens in a divorce situation. She's got the whole loan on the house, he's discharged, but he keeps title to the house. And typically, that's what happens. And I guess if that had happened here, he might not have gotten anything, but his name is still on that house. That debt is on the house. I mean, I don't know how the debt either. As the one half, the whole intrigues me because that loan was on the whole house. It wasn't on one half of it, but now she has a 1/2 interest and she's the only one doing it. So, I mean, it's a good bar exam question for any students listening as to what that means down the road.
I think it would, Your Honor, but again, the record evidence here is that the in re rose should not apply because at all times they were seeking to collect the full amount of the debt from the debtor, at all times. And there's not one shred of evidence that after the discharge, even after the order of surrender, that the creditor took one affirmative step to acknowledge the effect of the discharge.
So let's go back to maybe the preemption question. I want to go at it two ways. First, since you've said most of this conduct is post-discharge, as Judge Wynn said, there's an order, an injunctive order, and one option is to seek contempt of court for a adjunctive order. My question is, the bankruptcy code could have allowed for or provided a private cause of action for conduct inconsistent with the discharge. Why don't we, they have one for the violation of the stay. Why isn't the Congress's decision not to do that part of the balancing of all the interest involved? I mean, you say bankruptcy is for a fresh start. That's certainly one purpose of bankruptcy, but bankruptcy is also to equitably treat creditors, and it's not all about the debtor. It's a kind of a compromise of a variety of interests. Why don't we look at the absence of a cause of action as a decision by Congress that, all you have is contempt?
Well, Your Honor, when you're looking at three different types of preemption, and only one of them, the parties have agreed that there's only one type of preemption that applies here, which is conflict preemption.
Why did y'all, I don't understand why y'all agreed on field preemption. A lot of the cases that talk about these things, say it's preempted on field preemption. That's a separate issue for y'all, but.
Your Honor, they specifically stated in their brief that they were only talking about conflict preemption.
I'll address that later.
And then, conflict preemption.
Even in going there, are we bound by your decision on what the law is on this case, or do we determine that?
Your Honor, you determine.
Conflict, you can agree all you want,
Yeah.
but it's the court that determines as to whether this amounts to conflict or field preemption.
That is
I think
correct.
in addressing it, you might want to address Judge Qualibon's concern, even from a field preemption perspective.
All of the generally speaking, all of the field preemption cases, and this is in our first appellant brief, provide that the bankruptcy code is not so pervasive as to preempt the entire field of anything revolving around the bankruptcy code. And there's numerous Fourth Circuit cases which somewhat touch on those issues. There was one case, the Dubois case, which talked about ability to collect on, or to assert a cause of action for violations of the FDCPA and I think a Maryland Consumer Protection Statute. And I believe Judge Diaz in his dissent found that that conduct would not be preempted under the bankruptcy code. And so the overwhelming literature is that the bankruptcy code is not pervasive enough to be field preempted.
Does that include conduct before discharge as well?
That I
Seems like
think
from what I've read, that's a stronger argument for post-discharge conduct than pre-discharge conduct.
that's the conflict, Your Honor. I think the timing of this is very important. I think that under the conflict preemption standard, the two things you have to show are physical impossibility or an obstacle to the bankruptcy code or the bankruptcy case. And if you look at post-discharge after a case is closed, there's no impossibility. There's no conflict there. The case is closed. The bankruptcy is closed. Everything is done. All that the creditor or all that the debtor is seeking to recover is for claims that occurred post-discharge, or even if it's based on an automatic stay after the case has already been closed. So there's no conflict preemption there. And there's a case that Judge Loretta Biggs in the Middle District talked about, which kind of analyzed those issues. And it said, plaintiff is not seeking to hold defendants in contempt for violating the discharge order. Rather, plaintiff's claims seek to establish liability under the North Carolina NCCAA based on defendants allegedly attempting to collect a debt that was no longer subject to collection, which is the exact same issue in our case. The defendant has attempted to collect a debt that is not subject to collection. And that debt, if it was a modification, if it was a foreclosure, the law would still apply the same. The debt is not owed. So our claims do not presuppose or are predicated on a violation of the bankruptcy code. They're based on...
That is, at least I guess the connection is, that is not owed because of the bankruptcy code. And that's where the federal law gets in the place of it. And why wouldn't you file a contempt proceeding here?
Sure. There's several reasons in this case, one of which we're dealing with somebody with military security clearance, that the filing of reopening of a bankruptcy could trigger, as I think you've seen in the factual allegations, that his security clearance was revoked for 1 or 2 months because of the credit scores and the failure to correct the credit scores. We also would like a jury trial. And if you file a motion for civil contempt, what you're saying is you have one judge, the judge that's in this case is deceased, the bankruptcy court judge, Judge Dowd. The plaintiff's lawyer who was representing the plaintiff is also deceased. There's just no reason to be limited by that remedy, especially when you have approximately 400,000 people a year filing for bankruptcies. The point of the bankruptcy is a fresh start. The point of the bankruptcy is not to limit someone's remedies based on a creditor's collection attempts. And so we believe, Your Honor, I'm almost out of time, that the Barnhill case...
You're out of time, but you may go into your rebuttal if you like.
Thank you, Your Honor.
Good morning. May it please the court, my name is John Lynch. I'm here representing the appellee, PHH. It's always an honor to be here, so thank you very much. I think we all can agree what started this was unfortunate. Anytime anybody files a bankruptcy, that's unfortunate. And he was divorced, filed the Chapter 13, went into it for a couple of years, then decided to surrender the property. Surrendering the property, Judge Wynn, I think you might have asked the question, that's just an intention in the bankruptcy of what you want to do with the property. You're notifying everybody you're surrendering the property. Then 2 years after that was done, there was a discharge, and that discharge was in 2016. Ever since that time, PHH has not foreclosed, and they've paid taxes and insurance on the property actually since 2013.
How does a foreclosure work? You got one of the owners who's now Tennessee in common, you're foreclosing against that owner who only owns a half of the property. So how do you foreclose on the whole, or can you just do the half?
You would foreclose on the whole because the wife wasn't paying either. So you have a default on both. The procedure would be a little different, Judge, because you'd file a motion to lift the automatic stay as to Mr. Guthrie, and then Mrs. Guthrie would just have to get notice. And the reason the foreclosure wasn't done here, usually, of course, we don't want to pay taxes and insurance and not get paid on our debt for 10 years. The reason it wasn't done is because Mr. Guthrie was active duty, and you have the Soldiers and Sailors Relief Act, and you have to take certain steps under that. And it wasn't done because of that. And then once this litigation was done, we don't file foreclosures without court permission when litigation. Judge, all three of you, this is an odd situation. And let me tell you from a practical why we believe this happened. Typically, once someone surrenders the property and they get a discharge, their bankruptcy attorney sends it, if they want to get the title out of their name, the bankruptcy attorney sends a quit claim deed to the lender and says, I want out of this property. That's one opportunity that should have happened by.
Surrender means give it to the lender.
No, surrendering doesn't have to mean that. It just means that's your intention. You have to take the practical step with the property and do a quit claim deed on the property. That's to the servicer and the lender. You're saying, we want to do a deed in lieu.
How can you do that if his wife, from both of them, you need it from the wife too?
You would have to do it, and that was the second opportunity, Judge, is during a divorce. So during a bankruptcy and divorce, you always clean up title. During a divorce, if you own something with someone else in real estate, you clear up the title, and this should have never happened, both at the bankruptcy stage, which was, Judge Wynn, I hear you, because the wife wasn't in bankruptcy and she was out of state. So that makes it, you could only quit claim what you owned. And that would be, we'd have to foreclose against the wife who was not in the military. But at the time of divorce, in most divorces, if you own property jointly, you would have a deed, either deed it to the wife, or you would go to the lender with a quit claim deed or a deed in lieu of foreclosure. The fundamental misunderstanding here is the effect of surrendering the property and the discharge. You get discharge out of the loan. You don't get post-discharge obligations under the deed of trust for paying the taxes and paying the insurance. The N. Ray Rose case speaks directly to that. You still have obligations after that. Once you're on a title to the property, you owe taxes and you owe insurance by contract. And you have those obligations. So they say fresh start. And they say, we're done with this. If you're still on the title, you have the burden, not the lender, to take you off of the title. You have the burden to get off the title yourself.
Counsel, on that point, from a factual standpoint, assume, accepting that, at least for the purposes of this question, if there's evidence that your client sought more than that, more than the taxes and insurance, sought the whole amount from the plaintiff, from Mr. Geiger, and if there's evidence that rather going through Mr. Geiger's attorney, you went directly to him on certain collection efforts, are those seem like, issues that, that's the main thing he seems to complain about under the Debt Collection Act.
Yes.
What's the problem with asserting those things, at least for post-petition conduct?
Okay, so if we were trying to seek money that was discharged, and the word discharged is all over their complaint.
Right.
They're saying every time we communicated with them, every time we sent a statement, every time we called them, we were violating the discharge injunction because we were trying to seek money that had been discharged. That is preemption. That goes to the core of what bankruptcy is about. That's a violation of the discharge order. That state statute's preempted on that issue. Because if you want to have a discharge injunction violation, you've got to go to the bankruptcy court and get a contempt order. You heard from
Well, that's one option.
Yeah.
But why isn't the other option to prosecute your rights under a state statute that prevents that kind of conduct?
That's where the bankruptcy preemption, we've cited the Gator case, we've cited the Fourth Circuit case, NVR, we've cited bankruptcy cases.
You've got to show, it's not preemption. You can't just simply say preemption and that's the end of it. You've got to actually show some conflict that actually impedes the administration of a bankruptcy estate. And when you have a case where the case has been closed for many, many years, as is the allegation here, why is it at all inconsistent with a discharged party to be able to, as I said, prosecute his or her rights under state law? It doesn't seem to me, clearly he could do what you said, go back to the bankruptcy court, open up the case, and move for contempt. That's one option, but why isn't the other equally amenable option to pursue his rights under state law?
Because that would be the conflict about the rights and adjudication of what was covered by the discharge order. You want to have a uniformity of laws and uniformity of how things are applied. You don't want state courts deciding what was discharged and what's not.
But the discharge, I mean, that's over. That's been ruled upon.
Judge, every time there would be a violation of a discharge order, the discharge order would already be entered. It would always be post-discharge conduct violating the discharge order. You wouldn't even have a discharge order. So
Why is, what's your concern about uniformity? I mean, it sounds like if your client sought recovery of discharged amounts, and there's a state statute for misrepresenting creditors' rights. I get one argument is that, look, the federal, the Congress has this bankruptcy scheme. They had this one, they have an injunction order. They didn't have a cause of action. That's the same question I asked. So I kind of get that, and there's some authority that might support that. But the other side is, we got a co-equal branch of government here, and part of their sovereignty is that they get to have causes of action. And they have this. North Carolina's Congress passed these acts, and unless they're preempted, I think they get to do it. And that's kind of our question is, okay, why is it preempted? I mean, the fact that there's overlap doesn't mean, it's preempted.
it's a direct conflict.
What's the conflict?
You can't adjudicate a violation of a discharge order pursuant to a state cause of action. That has to be done through a contempt proceeding. Let me also talk
What's the case that says that specifically? Anything?
We've cited 6 or 8 bankruptcy cases. We've also cited the NVR case that talks about the depth and the predominance of the bankruptcy code, and you don't want to have conflicts between state law that adjudicates the same conduct that the bankruptcy court is supposed to.
So if a state law imposes liability for seeking debts that were discharged, how does that conflict with an injunction which prohibits seeking monies that are discharged? It seems to me like it's consistent. It just provides different remedies.
That's the case law, Judge. It's a direct conflict between what is discharged and because absent the discharge order, there would be no factual allegations that there's a violation of this North Carolina state statute. The entire case is about a violation of a discharge, and that's the thrust of the preemption. One factual statement I think that already, and one in the record, is we had in our statements and in our phone calls disclaimers. Mm-hmm. And the disclaimer the exact disclaimer was approved by this court, the Fourth Circuit, in the Lovegrove case. And when we have the disclaimers, what it's saying is if it's been discharged, this communication about the past debt is just for informational purposes only. And that has been affirmed by this court. And one reason we give that information is because the personal liability may be discharged, but the information may be important because you may want to reaffirm with the lender and the servicer.
When did your client first receive notice or indication from Mr. Guthrie that he's not responsible for this debt because he's been discharged from it?
The discharge order was entered in 2016.
And then the letters and things commenced. And at some point in time, when did he communicate to your client that these letters should not be coming to him because he's discharged?
There's no direct communication on that. And it's something, Judge Wynn, even if he said it was discharged, we still send the statements and have the phone calls for informational purposes only because there's taxes.
Going to someone other than just to him because it resulted in what he alleges to be some negative situations. It's one thing to send a letter to him and no one else. where else does this communication go to?
It should go to him and his wife, to the extent we have it addressed and
How does the
contact.
credit people find out about it?
So the credit people find out about it is, we obviously do monthly reporting, but and are you asking about the Fair Credit Reporting Act?
I'm actually, the negative implications that come from it. It's one thing to send a notice just to him and nothing happens. We're just letting you know to pay your debt. But it's another thing to send one, and then you have other obligations to notify credit agencies. Somehow the military knows about it, and that, how does that come into play here? Because it's one thing to say it's a benign letter. We just send a letter with a disclaimer on it, and that's the end of it. But apparently the credit agencies and stuff don't read that little language down at the bottom that it says the disclaimer, and therefore, if you're in bankruptcy, and we're gonna go check to see if you're in bankruptcy, I don't know what the obligation, how you get rid of that. Maybe the person who is being the subject of it tells them, no, I'm out of this or whatever, but.
So they complained, Judge Wynn, about 3 credit reporting disputes in this case. All 3 happened in 2019. And we do have an obligation, if we get a dispute, the way the process works under the Fair Credit Reporting Act, to have a claim, is the borrower has to make a dispute with what are called CRAs, TransUnion, Equifax, and Experian. Then they send a dispute to the furnisher, and we were the furnisher. And we got a dispute in 2019 and 2020 from the 3 agencies. We reported back, investigated the dispute and reported back. The Equifax one, the only record evidence is we didn't receive the dispute from Equifax. On TransUnion, we recorded nothing being owed. And then with Experian, there was a little derogatory credit that was reported to Experian. What the district court held was there was no causation because of the credit denials, and any other damage that occurred was not caused by these credit reporting by PHH. And with respect to the security, which I'd like to say to the court, first of all, he never lost security clearance. It was suspended for a month because he didn't submit the information in time, never lost his security clearance, and during this time period, he was promoted. So there was the district court found there was no adverse effects with security, and the credit denials he had on various cars or mortgages were not caused by PHH in the credit reporting.
Can I ask you a question go back to the disclaimer? I have 2 points to make about that, and I'd like you to respond. So it's true, I agree with you that the disclaimer, I think, is something that's been sanctioned by this court, and I don't have any quarrel with that. But I don't think it's correct to say that that is intended to be for lack of a better term, a get-out-of-jail-free card in every instance. I mean, if you've got a creditor who is sending a barrage of so-called information to the debtor, at some point, I think any court would say that that's actually an attempt to collect the debt and not an innocuous disclaimer. So that's the first point. And the second point is you indicated that there were both letters and phone calls, and the plaintiff has alleged, at least with respect to the phone calls, that there were no disclaimers attached to those. So isn't that a factual dispute that we can't resolve?
So on the last question, Judge Diaz, the record evidence is there is a disclaimer made in the beginning of every phone call, and that was not disputed by the plaintiff. In the record, every phone call we make, we do the same disclaimer at the beginning of the phone call.
Where's that in the record?
I don't have the page number. Okay. That's in the record.
But before you leave, if you don't mind, I mean, I recall that being evidence that, you know, you presented about how things are done. But to Judge Diaz's question, I thought that Mr. Guthrie disputed that. I thought we, you know, and you may say, no, we got this custom, here's how we do it, but we don't have all records of all the phone calls. It's not like we have transcripts of everything. So as I remember, he said, no, that's not true. And so, and that was in the record too. Again, I'm not expecting you to agree with him, but I mean, didn't he contest that in the record?
I don't think so.
You don't think so?
I don't think so.
Okay.
And he may have. And I guess that still goes back to, we had the right post-discharge to communicate with him because he's still on title. You've got obligations with respect to taxes and insurance, even though there's a discharge and you surrender the property. And you have to give someone the complete picture of what is owed, both from taxes and insurance and the total debt. During the recession, people were, even though the personal debt was discharged, people were reaffirming they would want to keep the property. They would, if they wanted to keep the property, they would need to know the total amount owed to maybe go refinance it. So there's a big distinction between getting out of a personal liability and still having title to the property. If you have title to the property, just like N. Ray Rose said, you've got byproducts of home ownership, and that's under the deed of trust. And the deed of trust between the lender and Mr. Guthrie said you had to pay taxes and you had to pay insurance and you have to upkeep the property.
So I think that's fair, but if you assume these facts, assume in the phone calls you weren't giving the disclaimer, and assume in the phone calls you were seeking from Mr. Guthrie the amounts that had been discharged. Putting aside whether your remedy is contempt of the discharge order or not, wouldn't you agree that assuming those facts, which I know you contest, that would be improper?
Yeah, so hypothetically, my hypothetical, let's say we called and said, you owe a payment on this loan and you've got to pay $800 in 15 days. And let's say we didn't give the disclaimer. That would be money that was discharged. He has no personal liability on it. That's a violation of the discharge injunction. We're saying that is preempted by the bankruptcy code, and his sole remedy for that is through contempt proceedings with the bankruptcy court.
So if there's record evidence that effectively you were doing that, maybe not with the specificity of $800.
I gave you an example.
But if because I thought said that that's what happened. Y'all called him, you didn't give any disclaimer, you didn't say you're calling about, you may have inquired about the wife, but then you went further with him. I don't know if any of that happened. I'm just saying that's what he said. And if that's true, it seems like there's a question of fact whether it's proper or not. And then our question is, if it is improper, is it preempted, or is it something that is not?
Yes.
Do you at least agree with that analytical framework?
I do. I think you look at the preemption first, because this entire case is about whether we violated the discharge injunction. Were we seeking money that was discharged? That is the predominant. If you look at the allegations in the complaint, they said after the fresh start, you chased us for that money. And we obviously have the disclaimers. And we're saying if we violated the discharge injunction, that is what's preempted. And we've cited the case law from all the bankruptcy courts and other courts that have cited that. One thing I'd like to say, when they were talking about a circuit split, they were talking about one federal law violating another federal law. This is bankruptcy code versus a state statute. This isn't federal law preempting another federal law. It's bankruptcy code preempting a state statute for the exact conduct that the bankruptcy court adjudicates and deals with. And it would always be post-discharge. You couldn't violate a discharge until a discharge was entered. And bankruptcy cases are reopened all the time for contempt charges and other sanctions. And actually, one remedy the bankruptcy court has is they can monitor a situation for a certain time period. So they have a wide discretion.
So is it your position you were not seeking the debt that had been discharged, you were seeking the continuing payments of like insurance and taxes?
Yes, that is exactly what we're saying.
Taxes, and I assume this obligation to pay the creditor arises under the mortgage agreement.
Yes, sir.
And he's still bound under the mortgage agreement, even though he's not bound to pay the debt.
Yes, sir.
So how do you have a mortgage agreement when a debt has been discharged?
That's in the deed of trust. There's a promissory note and a deed of trust. The deed of trust would be relieved and released when the title was transferred.
So this is a new debt, not a debt under the mortgage.
Yes, sir. Yes, sir, Judge. It's a
That
post.
is paid in taxes, and those taxes are due to the property people who can then foreclose on the property. All of it has to be driven by how much equity you have in the property, because a lot of times you don't care.
That's our, Judge Wynn, that's our exact point, is because those are post-discharge obligations for taxes and insurance. Let's say there's equity in this property and Mr. Guthrie may want to keep paying the taxes because he could sell the property and make money. He's got in the N. Ray Rose case, the lender does not have the obligation to change the title.
One follow-up back on preemption. I raised this with your colleague. My review of and this may be more in the context of the violation of the stay, there was a lot of discussion about field preemption in the case law that I looked at on that. And it may be that the reason I'm surprised you conceded it, and I'd like to hear from you about why field preemption is not applicable. And in doing that, in thinking about it up here, it may be that's because we're more in the realm of violating the discharge than the automatic stay provision. But yeah, anyway, because at least in the stay cases, the preemption discussion seems to focus on field at least as much as the conflict uniformity basis.
Judge Quattlebaum, you said it perfectly. So from when he filed bankruptcy till the discharge order, you had the automatic stay. Then the stay ends in 2016 when the discharge is granted. This case focused on post-2016 conduct. The lawsuit was filed in 2020. Any conduct before 2016 would have been time barred. If you read the allegations in the case, it all focuses on violation of the discharge order. They're really, between 2013 and 2016, the violation of the stay is just not the claims in this case. They mentioned the stay in the allegations, but the claim really is violation of the discharge order. And we believe conflict preemption, and there's actually a fourth type of preemption that we mentioned. It's called a uniformity. I don't know if you saw that in our briefing. And we believe that applies, and conflict preemption. I'm mindful of the case law on field preemption and automatic stay, but we believed it was more appropriate on the conflict because of the direct allegation and claim here. Thank you.
Your Honor, the facts matter. And there is not one single piece of evidence in this case that demonstrates that after the discharge, they were solely seeking to collect property-related expenses. Not one piece of evidence. So this whole discussion that we're having about Henry Rose and its implication, it doesn't matter because there is no mortgage statements. Pay the full amount. Reports to the credit reporting agencies. Pay the full amount. The calls. Pay the full amount. So the truth matters here, especially at summary judgment. And the truth is, through all of the mortgage statements, through all of their activity, even through the 30B6 testimony, there is no evidence that they made any steps to affect.
Well, at least from your perspective, a disputed fact exists.
Well, Your Honor, it's the only fact because the only evidence that we have from PHH is from someone who submitted an affidavit after the case and had no personal knowledge whatsoever of any of the communications. And that's why we moved for summary judgment, because there is no dispute that they were always attempting to collect on the case, on everything. So the fact that they made this after lawsuits filed argument.
Consider the disclaimer. If you got a disclaimer that says we're not coming after you for that,
Yeah.
and all that's left is the post.
Well,
That's why I say maybe a dispute might exist.
Well, and let's talk about that disclaimer. One, Lovegrove was an unpublished case and appeared to kind of be victim
That
blaming.
won't work very well here, so.
Okay, well, maybe this will, Your Honor. Lovegrove specifically said this is not a case where a creditor harassed the debtor or tried to pressure the debtor into making payments through multiple phone calls or threats. That's our exact case. For 8 years, that's exactly what happened. And so after this legally generated reason for why they were contacting the plaintiff isn't supported at all in the record. And we do have the transcripts of the phone calls, at
So
least some of them.
if we say there's a question of fact about what happened, whether it was just taxes and insurance or everything else, we got that issue, and we got to then grapple with the preemption issue, right? That, I mean, that's,
Correct.
and, you know, there's, back to, I guess, my question earlier, and, yeah, I've kind of posed it to both of y'all to address it. Yeah, again, if you're really, if the main issue is you're seeking discharge debts, why don't we consider the fact that Congress didn't allow a private cause of action as, you know, as a decision that supplants state law?
Your Honor, when you're looking at preemption, and this is U.S. Supreme Court as well as Fourth Circuit law, the presumption is that it's not preempted if you look at the Wyeth cases and some other cases. So it also doesn't, the code also doesn't say you can't assert these claims. And if you look at just how the practice of this is, almost all of the bankruptcy courts in the Fourth Circuit have said these exact claims are not preempted. There's the Gator case, which was referenced, which was expressly overruled by Judge Biggs in the Middle District. So one, we have to deal with the actual facts at issue here. I will just note the FCRA claims, there was something said about that. The FCRA results specifically indicate that the client was delinquent in his payments and that the full amount of the balance was owed. And this result of the TransUnion result in 2019 was the basis for the denial of his car loan. And we also have other disputes that went back to 2015, 2016, 2017. So if the bankruptcy court judges are not finding preemption, and they're the ones that apparently we need to protect, then there is no conflict. Just because there's similar claims does not mean that there can be overlap without conflict, and unless you show that there's some impossibility as opposed to just citing to some case law.
All right, thank you.
Thank you.
I'll ask the judges if you have further questions. Thank both of you. We'll come down and greet you, and then we will proceed we will take a short recess and come back to the last two cases.
This honorable court will take a brief recess. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
All right, be seated, please. And we will proceed to the third case on the calendar for today, United States versus Walgreens. And we will hear from Mr., pronounce your name.
Totaro, Your Honor.
See how good I'm getting at that now? Totaro.
Perfect, Your Honor.
Thank you, Mr. Totaro. Please proceed.
Thank you. Martin Totaro on behalf of the United States. This is a False Claims Act case where Walgreens seeks to avoid liability for government payments it received based on fraudulent submissions filed by one of its pharmacists. These submissions involved conditions attached to very expensive drugs. A full treatment for a single patient for one of the drugs was almost $100,000. If Walgreens wanted to attack Virginia's prior authorization conditions, it should have done so before lying about complying with them. But it can't challenge the conditions as a defense in this False Claims Act action. If this court reaches the merits.
Just a preliminary thing. Help
Yes, Your Honor.
kick a few cogs out of my head on this case here. This action arises because a pharmacist who was working for Walgreens deliberately, and now that's settled, fraudulently altered prescriptions.
Well, Walgreens in its brief says allegedly, but yes, she was prosecuted for similar conduct.
Assuming she did, let's say she did. And Walgreens kicks in the picture. They don't know anything about this employer that's doing this the whole time, employee who's doing this the whole time. But Walgreens is liable because, one, I guess it didn't pay back the money, which might be some sort of a reverse claim, or because of respondent superior, or what is the, and I know that's not, for some reason it's not for us, but it was just intriguing to me how we skipped to Walgreens. You are now violating False Claims Act because you got an employee who has done something that did it.
Right, Your Honor. So Your Honor is correct with respect to the overpayment for the reverse false claim. And then the issue of, I think it was litigated below on vicarious liability. She wasn't just a pharmacist, she was a pharmacist manager, but the district court didn't decide the motion to dismiss. And here again, we're on a motion to dismiss and instead decided it on its theory of the statutory scheme. And so presumably that might be an issue
So
going
that may
forward.
still come up as to the liability of Walgreens under this. Did I say Walgreens?
Yes, Your Honor, it's Walgreens. I believe if this court were to remand based on what the government says is a fundamental error in Section 1927 in Walgreens' interpretation, I believe Walgreens would not be
Well, last
foreclosed.
question. If, and ultimately, you're talking $800,000 or so. If they paid the $800,000, given the state of what we now know, that it is, that $800,000 should have been paid to Walgreens, but given the state now, would the government then give it back to Walgreens? You follow me?
I don't think I do, Your Honor. I
Well,
apologize.
if, let's say we start out and cases against the employee and she's fraudulently, and they say, well, you built us out of $800,000.
Oh, I
and you got
understand,
more.
Your Honor. I
And then
apologize.
Walgreens turns around and scribbles a check out and sends it to her for $800,000. And then it is determined that Virginia should have done this from the first instance. And these people should have gotten this, which I assume each one of those that didn't get it may have some kind of action or whatever. And Walgreens says, I just gave you $800,000 based upon you denying claims that you should not have paid. Give me my money back. Would you give the money back?
So the the pharmacist did not pocket the $800,000. The $800,000 went to Walgreens.
That's what I'm saying.
Right.
Pharmacist is out of it. I'm saying Walgreens pays it back. Walgreens pays it back to Virginia based upon what their pharmacist did. Then you find out Virginia did something illegal in denying this. Let's assume that happens. Do you then pay the $800,000 back to
I understand,
Walgreens?
Your Honor. So first of all, there's also potential for treble damages in a False Claims Act action, but just setting that aside for a moment, the core principle of the no collateral attack rule is that the underlying validity of Virginia's requirements are off the table. If Walgreen had wanted to challenge those conditions, they should have done it at the time.
Well, I'm
And
only talking about now.
Right,
Trouble
and now
damages
based on-
all aside and all that stuff, you're dealing with False Claims Act. I'm talking about you paid something to Walgreen, and you maintain that Walgreen got it and shouldn't have got it because they sent something false, but then it's ultimately determined, Walgreen then gives it back to you, 800, then it's determined, well, you shouldn't have had those conditions that kept Walgreen from getting paid. My question is, does Virginia or the government then give Walgreen its money back?
So I think it would depend on how the court decides to resolve this case. If the court said that Walgreen had to challenge those conditions at the time and cannot now offer an after-the-fact collateral attack, then Walgreen, that issue is just simply off the table.
But
if-
off the table with respect to materiality, right?
Off the table with respect to the entire False Claims Act claim, like the
Including, I think, I had the same question as Judge Nguyen. If there really is no damage to the government because the government should have paid the claim all along, then don't they have a defense to any damage claim?
they might, Your Honor, but that's not what they're arguing here. We're just
Well,
simply.
not yet, but at some point they would.
Just to build on that, I mean, this case is up here on materiality, and we'll, that maybe there's an issue about that, maybe it's not. But the way the False Claims Act works, as I read it, you know it better than me, but it provides some statutory damages, some kind of fine type damages or relief, and then it says damages. And why isn't the claim that you don't have any damages a claim about you're not meeting, being entitled to damages, as opposed to what you call a collateral attack? If you're seeking damages, and here you are, I think, you're seeking the $800,000, they're saying, no, you don't have any damages, you don't have any loss, you got, wrongful, if you got that, it would be improper.
Right. So if the court agreed with the government on our first argument, then the case would be remanded. On remand, Walgreen would not be able to contest the validity of Virginia's conditions. If Walgreen could otherwise somehow say that, well, you actually didn't, sort of tried to shoehorn it into a question of damages, then perhaps that's a possibility, which also suggests that this court could decide both our first argument and our second argument
To a separate action. Why,
I'm-
you go back and you collect $800,000 from Walgreen. Why come Walgreen can't then file an action that says, you owe me that money back because that was illegal that you just got this money for?
So again, I think it would depend on whether, well, first of all, this is extremely hypothetical because Walgreen has not paid us back.
Hypothetical, because what you're saying is we need to go through these little technical steps here for the ultimate results of where, as Judge Qualibon indicates, there may not be any damages here. And so if there's no damages, then, why would we be standing here? And how does Walgreen challenge those requirements? Where's that
Walgreen,
stand?
Your Honor, could have challenged the requirements before it decided to commit fraud. It could have filed a declaratory judgment action in federal or state court. We have this in the brief, and Walgreen did not contest it in their response brief. And at a bare minimum, Walgreen could have said, HHS, look at what Virginia's doing here. It's unlawful.
Declaratory judgment action for what purpose?
Walgreen
Declaratory
would,
judgment in terms of, not on the False Claims Act, but on what?
right, this would be before Walgreen decided to commit fraud. It would be suing Virginia under 1331 and 1983, saying these coverage conditions are illegal. Court decide that.
Let's get back to the facts. It's pretty clear. Walgreens didn't know this employee was done, but I understand the vicarious liability, the whole bit. Walgreens doesn't know this, so it's just odd. You can have an employee, and it's got thousands of them. Each one of them do this. They've got to be responsible to the tune of a False Claim Act for every employee in there who files a false claim.
No, Your Honor. This again goes to an issue that wasn't resolved but was briefed by the parties on vicarious liability. The government's position wasn't that every single line employee at Walgreens would be
Managers.
liable, but this
Managers.
is a manager. Yes.
Every manager they probably got thousands of those.
I don't know how many managers they have.
But I got a bunch of them. Let's see, every one of them, this can happen if each one of them at a certain level, if you got into supervisory, every time they do something without the knowledge of corporate, in 1983 type actions, at least when we're dealing with municipalities and others and seeking this type of liability, Monell type situation, you got to show there's a policy or something that fosters this kind of behavior. And I don't know if vicarious liability carries that here because it's not before us. But it's just
Again, Your Honor,
interesting where we are today with this argument on this. And I mean, I get it in terms of there's $800,000. But what makes this a different situation is the question of the legality of the conditions that were there placed on it that kept these people from getting these medicines.
And Your Honor, we agree that where we are today is a procedural anomaly, but that is because Walgreens chose to file a motion to dismiss rather than, for example, developing a record on the actual facts that these particular prior authorization conditions were unlawful. And so what they would have done, which is what plaintiffs have done in all of the other cases they cite, is have a separate action where they say what you are doing doesn't violate the prior authorization authority that allows, by the express terms of the statute, to subject, quote, any drug to prior authorization. They would have said these conditions violate some federal or state provision. And there's sorry.
I don't mean to cut you off, but I mean, I think we understand your collateral attack argument, and we agree with that or we won't. But let's talk about what I think you're getting into now is the merits of whether these conditions were or were not illegal. If they're illegal, maybe they should have done maybe they should have challenged them separately. Maybe they go to whether you have damages. We can maybe work on that later. But the core issue of whether it's proper for you to use the prior authorization statute to, refuse to reimburse on a cost basis for medically necessary authority. It seems like your argument hinges on the prior authorization provision alone. Is that right?
Yes, Your Honor, Section 1927 D1A.
Okay, and so how do we square that with the Supreme Court statement in Walsh that that if once a drug manufacturer enters into a rebate agreement, the law requires the state to provide coverage for that drug under its plan unless the state complies with one of the exclusion or restriction provisions of the Medicaid Act.
Yes, sir.
And that's a case where prior authorization is being talked about. So how does that not put an end to your argument that you can look at the prior authorization section?
So, Your Honor, D1A is so Section 1927D lists limitations on coverage of drugs.
Right.
And then D1 lists permissible restrictions. And it applies that restriction provision both to D1A, which is the prior authorization provision, demonstrating that prior authorizations can be restrictions, and D1B, which allows a state to exclude or restrict coverage of other outpatient
What's the
drugs.
point then of B? I mean, doesn't that argument make B, unnecessary? Because if that's right, prior authorization can be the basis for any substantive restriction. So what's the point of 4 specific substantive restrictions if there's a whole universe that could be covered?
2 responses, Your Honor, a legal one and a practical one. The legal point is that prior authorization only allows a state to restrict coverage. It does not, in the grant in D1A, allow states to exclude coverage from a drug altogether. That separate authority is given in D1B. And so D1B is a greater authority because it allows a state to exclude coverage of a drug altogether. And the second point I was going to make was a practical one, which is that this is how prior authorization has been operating for 3+ decades, and states have not abused their prior authorization authority in that way. And that's because of a very practical point. Imposing these prior authorization conditions are very costly. It bothers constituents. It's done under the specter of the federal government looking over your shoulder to make sure that these restrictions don't go too far. And it also
And that may be, and look, I get the point. I get the point that, you want to make sure the programs solve it. And at some level, if you don't have cost restrictions, you could have an issue. The question is whether the statute lets you make that determination. And in other parts that talk about medical treatment and medical services, there are provisions that kind of talk, that have language that the courts have interpreted may allow for a more cost-based thing. But I didn't see that, like, for example, I think AA19, I've seen that provision, but you're not making that sort of argument. And I didn't see that sort of provision in the drug portion of them. So I'm just trying to see where you get the authority that you're doing this. Maybe that's being done for all these years, but that, might have been wrong all these years.
Your Honor, it's been done for all of these years, and Walgreen does not deny that. And to go back to your reference to the Walsh case, Walsh said what the 1990 Act was intended to do was codify, not limit, states' prior authorization authority. And one of the cases it cited as an example is the Cowan case from California that included prior authorization conditions that would, in Walgreens' view, be substantive and unlawful. So it's not just 3+ decades of practice. It's also that the Supreme Court in Walsh said it was codifying that prior practice too. So we're talking about generations of prior authorization conditions. And I would also I'm well into my time for rebuttal, and I apologize, but if I can make one final point, there is a disconnect in Walgreens' theory. Walgreens first says there's no such thing as a procedural prior authorization condition. There's no restriction on that, in your honor, under the plain text of 1927D. It's just talking about permissible restrictions. But on the other hand, they're saying, well, also there's this separate thing that medically necessary drugs also can't be subject to prior authorization. But the district court's opinion goes far broader than that medical necessity point because there is a panoply, a full panoply of prior authorization conditions across the nation that are substantive under Walgreens' position and yet have nothing to do with medical necessity.
So you've reserved a little time in rebuttal, and I understand Mr. Minogue wants to speak for a brief period of time.
Thank you, Judge Wynn. May it please the court, I'm Jordan Minot, Assistant Solicitor General here on behalf of Commonwealth Virginia. I'm joined by Erica Maley, Deputy Solicitor General. My colleague from the Department of Justice discussed the merits of the False Claim Act issue, and the Commonwealth fully agrees with that position. As we noted in our reply brief, Walgreen in its response brief agreed with the Commonwealth that the standard for the state law claims is identical to that applied to the False Claims Act claims. I'd like to take a few minutes, however, to highlight that Walgreens' legal theory could have disastrous legal consequences for the administration of state Medicaid programs. As my colleague discussed, according to Walgreen, it may keep the money made on its behalf by the lies of one of its pharmacy managers to the government, so long as the Walgreens can, after the fact, convince the court that some aspect of the Medicaid regulations with which it refused to comply were unlawful. That's true, according to Walgreen, even if the employee who lied and made money for the company spent substantial time in federal prison and could not avail herself of the same defense. Walgreens' legal theory also risks creating a sea change in the way that states administer their Medicaid programs. Typically, the government administrators of these Medicaid programs work collaboratively with doctors, pharmacies, and representatives of the private sector to dole out the limited resources that Virginia has available to cover its Medicaid patients. As part of that system, many states, or every state, including Virginia, has prior authorization requirements that don't necessarily map on identically to the subsection D1B criteria. And that cooperative system, as my colleague pointed out, has functioned well for decades.
But that may be right, but isn't that a hole in the statute? Isn't that a problem for Congress? I mean, if your argument is that D1A is broad enough to cover it, I mean, I hear that point, but it seems to me to make D1B fairly useless in terms of its role there. And I get the point. I mean, I get the cost. I get there's limited resources. And if Congress had said a provision, that addresses that, we wouldn't have this issue. But the question is whether they did or not. And there's provisions in other parts of the Social Security Act that suggest they apply. I know I'm getting out of the Virginia statute, so I may be a little bit unfair. But when you talk about disastrous consequences, we don't like disastrous consequences, but we apply the law, not make policy decisions.
Judge Quattlebaum, I disagree that it's a problem for Congress because I think Congress has already somewhat solved this problem. What Congress did in this scheme that it created was it gave states the flexibility to administer their prior authorization programs to meet the challenges of administering a state Medicaid program. The other provisions in the Act apply to other ways that states may control access to drugs, but the prior authorization scheme is meant to grant states that flexibility. And some of these concerns are not necessarily just cost-based. As we would have shown if this case progresses, at the time that these restrictions were in place, these drugs were brand new and sometimes hard to come by. So there's other concerns besides cost that may drive a state to have some similar restrictions on its prior authorization scheme, and the scheme put in place by Congress explicitly gives states that flexibility. And as I'll just touch briefly, as my colleague pointed out, Walgreen up front, or one of its representatives, or indeed anybody else who might have been affected by this, could have sought a declaration in either state or federal court that the requirements were unlawful. Walgreen did not do that. Instead, when the government came to collect the money that had been taken from it fraudulently, Walgreen decided to raise the claim then. You should not be allowed to profit from that tactic. The Commonwealth asked this court to reverse the decision below. Thank you.
Thank you, Mr. Manott. We will now hear from Mr. Phillips on the other side.
Good morning. May it please the court, I'm Jonathan Phillips of Gibson, Dunn and Crutcher on behalf of Appali Walgreens. Your Honors, the government brought this lawsuit to reclaim payments to Walgreens for curative, life-saving hepatitis C drugs that the Medicaid program was lawfully obligated to pay for in the first place. And the district court came to the common sense and legally correct conclusion that Virginia's unlawful payment criteria could not have been material for purposes of the False Claims Act, and therefore the government has not pled an essential element of its case.
It's a general principle that a law is presumed to be lawful until you make some determination that it's not. Why is the presumption of lawfulness doesn't apply here? That you don't just, the average citizen, when you're dealing with something, you just don't go into civil disobedience or quit something because you don't like it without the consequences of whatever follows from it. But why does that not apply here? At least in terms of the initial False Claims Act, which then gets into what Judge Quattlebaum and I talked about, damages. It seems to be an intriguing question to me. That yes, so what if you find it, but if you ultimately determine there's no damages? Or is that a separate question, the question of damages and whether one has been in violation of False Claims Act?
In part, it's a separate question, and in part, I think there's a common thread to both of those things, which is materiality is an element of a False Claims Act cause of action. And the Supreme Court interpreted the materiality element in Escobar, and it said, it premised the idea of materiality on the legal option to pay or not to pay. It talks about the influence that information might have, that a representation might have on the recipient of that information's quote unquote choice of action. Here, Virginia had no choice of action to not pay because the coverage criteria that it was using were unlawful.
But isn't the question whether or not it would have actually influenced the decision maker, not in hindsight with full information? And in this case, clearly, had the Medicaid officials not been misled, they would not have paid the claim. So, I mean, isn't that the end of the story?
No, I would say no, Your Honor. The statute begins, Section 1927 of the Medicaid Act begins with the idea that a state like Virginia that elects to cover prescription drugs for its beneficiaries must pay for any covered outpatient drug, which means that it is required to be dispensed on a prescription and that it is FDA approved. That is the starting point. Every drug that meets that description, and there's no dispute that the drugs here meet that description, must be covered. Now, if Virginia wants to peel away from that with limitations on coverage, there are ways they can do that that are enumerated in subsection D and specifically subsection D1B. And so to answer your question, Judge Diaz, the starting point for that government official who is deciding, do I have the option to pay or not to pay, the starting point is that they must cover the drugs here.
I get that. I don't dispute that, but if they choose not to, mistakenly or otherwise, Escobar doesn't talk to that scenario. It just says, how do the facts actually influence the decision maker in this case? And in this case, the misrepresentations, wrongly or rightly, you say that they should have covered the drugs, they didn't, but they would not have but for the misrepresentations of your client and its manager. And it seems to me Escobar answers the question that's material. The question of whether or not it's legitimate, as the other side says, is a question that they claim you can't now collaterally attack. You had options to do so beforehand and didn't.
I think the Escobar court does not quite say, did the information actually influence the decision maker in question, which would be a causation issue. The question is, was there an ability for it to have affected the decision making? And that government official that you're thinking of, Judge Diaz, is commanded by the Medicaid Act to pay these claims. They are commanded to pay for a covered outpatient drug that is not subject to one of the recognized limitations under the federal statute. And as Judge Jones correctly ruled below, that means that the government is not able to establish materiality here.
So what, I mean, it's both Judge Wynn and Judge Diaz points kind of, it wasn't I guess your point is you should look at it and determine that it's illegal, on your own. And so, and so if you could look at it and determine it's illegal, it can't be material. It seems odd, though, because there was no declaration that it was illegal until it happened at the district court. So it's almost as you're getting, a declaration that it's legal and is then like putting a time machine and goes back to the time they were making decisions and they say, we should have known it's illegal. I guess something could be so obviously illegal that meets that. But that's what's problematic to me is we didn't know, arguably you didn't know it was illegal at the time the decisions were made. And as Judge Diaz says, it seems like it was relied on. And so, anyway, I think the legality of this presents concerns or problems in the damages section of the False Claim Act. But I'm just not seeing it in the materiality context.
Well, Your Honor, I would say, first of all, I don't think we do need a time machine to go back in time and say to the state at that time, these criteria were illegal. Because at the time, during the relevant time period, the federal government itself in Release 172 said, we do not think these specific criteria that you are using to exclude these drugs from broad swaths of patients are consistent with the federal requirement to cover covered outpatient drugs for which the manufacturer has entered into a rebate agreement and have been prescribed for a medically necessary, medically accepted indication.
Well, we do not think does not make it illegal.
That's true, Your Honor, and we're not asserting that release nor did the district court below, that release invalidated the criteria as a matter of law. But what Judge Jones, I think, correctly found and reasoned was that it is certainly, when you read the statute for yourself, it's certainly consistent with that conclusion. And I was simply responding to Judge Quattlebaum's, hypothetical. Do we have to go back in time? And people were thinking about this that way
Well,
at the time.
but I think you would have to go back in time because didn't the scheme predate the publication of the release, the guidance that you're relying on?
I would say bookended it, Your Honor.
Well, that's a nice way of putting it. But either predated it or didn't. Which one is it?
I believe the release came out in 2016, Your Honor, and the relevant time period of the claims in this case are 2015 to 2017.
So you couldn't have relied on that.
Your Honor, reliance, let me stress, reliance is not an element of the False Claims Act.
No, I get that, but you brought it up, so it clearly can't be relevant if it didn't happen until after the fact.
And the point I'm really trying to make at the end of the day is Escobar talks about the potential influence, not the actual influence, the potential influence on a decision maker's choice of action. And it cannot be, I think this is common sense, but it cannot be that a decision maker can make the choice to violate a law, can make the choice not to follow the command of the federal statute that governs the entire program. And in fact, that's the Kaiser Steel line of cases that we cite that says the court will not enforce an unlawful payment term. The law will not compel what it has forbidden and denounced, which is the Koppel v. Hall case says that.
And that may be, and illegality is a principle that is applicable in lots of areas of the law. Some federal places like we're talking about is contract law. I mean, it's all over the place, but I've never really heard it or seen it in, even in doing work on this case, to be imposed on the materiality part of a fraud claim. Usually it's a separate theory that may be something that applies here. Like I said, maybe in the damage. I've just never seen it in this context. And so, maybe we've been wrong in where it falls all these years, but I've just never seen it in the materiality world.
Well, I would hazard to say, Your Honor, that it's not common for the government to bring enforcement actions based on unlawful conditions, but
if you go we do a common law fraud, often come in the contractual world. I mean, I don't think I've ever seen illegality in that. I did private practice for a few years and dealt with fraud cases from time to time, and it seems to me it's an important concept and a relevant concept. I'm struggling to see where that it fits where we're talking about here.
I think bringing the concept of an illegality defense that's talked about in Kaiser Steel in those cases, bringing that into the concept of materiality only strengthens its applicability. Because in those other lines of cases, we're talking about cases where the elements of the plaintiff's cause of action were satisfied. Mm-hmm. And we will nevertheless say that we are not going to enforce against the defendant because of some illegality. Here, as Judge Jones correctly found, you don't even get there because it's the government's burden to plead materiality under the False Claims Act. And you can't do that. The government has not done it here, where the decision maker did not have a legal choice not to pay under the circumstances alleged.
Can I ask a question about, just to get oriented a little bit, not about what the answers are to anything, but there are certain claims that Walgreens provided false information, and there are certain claims about overpayment that hinge on that there being not that the money is not paid back. On the ones that involve overpayment, even if we were to disagree with the district court on materiality, do we still have to reach the illegality issue? Does that make sense?
I'm not sure I completely follow that.
So, I mean, in theory, we could say, hey, this illegality stuff is out there, but it doesn't have anything to do with materiality, and we could, vacate on that basis. If we do that, what do we do? Do we still need to address whether or not the restrictions were illegal on appeal here?
So I would agree with the first part of what you said, Judge, that you do not need to reach this concept of an illegality defense if you agree that materiality was not
I didn't
adequately
mean to
pled,
say
but-
it that way. I must have said it wrong. Assume we think illegality doesn't have anything to do with materiality, so that was wrong.
I see.
Then do we need to address the illegality for any other reasons on the appeal?
As to the other claims in the case, the Non-False Claims Act claims, common law claims for overpayment, I think the parties have agreed that essentially those claims rise and fall with the conclusion on materiality, because the overlap is, did Walgreens receive money that it was not entitled to receive? That is the crux of a False Claims Act case. That's the crux of their common law overpayment claims. And we think, for the reasons we've asserted with respect to the validity of the payment criteria, it's quite clear that not only were they entitled to receive it, the government was required to pay it. And I would say that, this is another way in which materiality is expressed in Escobar, in the Fourth Circuit, and in other circuits. The question is asked, did the alleged misrepresentation go to the essence of the bargain? Did it go to the central purpose of the payment under this program? And I would submit that it goes to the essence of the bargain, that the Medicaid program pays for life-saving medically necessary drugs that do not meet one of the limitations that are recognized in the statute. It is the essence of the bargain that when a doctor prescribes a life-saving drug for a patient, and that drug is prescribed and claimed for payment by the Medicaid program, the essence of the bargain is that the Medicaid program pays for it unless there's a specific reason they have said that they won't in the federal statute.
So let's talk about the federal statute. We have Supreme Court cases like, and these weren't cited, and they may not apply, that, there's Alexander versus Choate, where the Supreme Court's talking about some of the provisions in the treatment and services realm of the Social Security Act. And they cite provisions that basically say that these provisions are for all the recipients. And that's been interpreted to say, hey, it's okay to draw some lines, even for medical necessary treatment that that are medically prescribed. In Alexander versus Choate, Tennessee cut the amount of permitted stays in hospital from 20 days to 14, not because it wasn't medically necessary, but because they basically couldn't afford to stay afloat if they didn't do that. That's at least one of the things we're saying here. Now, I'll grant you that's not a drug rebate thing, so it may be that's our difference. But is that concept not permitted in the drug world at all? That if the state says, look, we can't maintain our program because of these costs, that's not something we can take into account at all, that you just you have to fund it into bankruptcy?
Your Honor, I think this part is the same with drugs and with services. The state absolutely can draw lines, and it can use prior authorizations to do that. But it cannot use the prior authorization process to say anybody on the other side of the line can under no circumstances get this drug. That is the problem.
What in Choate, Alexander Choate, they said under no circumstances can anyone stay more than 14 days, even if you need it. They just cut it off because they couldn't afford, they thought, to keep doing both. Why is this different? And that may be unfair because that's not in the briefs. Feel free to say, yeah, I hadn't read that in a while. I'm not trying to play gotcha with that. I'm just trying to get this concept of they've drawn this line that, not on medical necessity, but on less medical necessity. And they say, if we don't do stuff like this, we go bankrupt. That seems not irrational. Now, maybe it's not permitted, but it doesn't seem arbitrary or irrational. And I'm just trying to figure out, is there an arbitrary or rational standard, or did Congress just not leave room for that type of analysis?
So I don't know the specific details of the payment rule in Alexander v. Choate, but I would bet that rule said we will only pay for 14 days as the default. It still must. It is the program is required to, in that situation, still allow a doctor to come in and say, but my patient needs 15 days and here's why. And that's what the prior authorization process is very good for. For doctors to say, you may not want to pay for, let's say, fibrosis score F1 or F2, but my patient really needs it for lots of the reasons that Amici have covered extensively. And the problem with the Virginia criteria, especially as they've been alleged and applied in this case, is they completely cut out that possibility. And I think what maybe short circuits this discussion is I heard a moment ago the government say they don't contend that the prior authorization process can be used to exclude coverage of drugs, but that's exactly what they have alleged in the complaint. They have alleged that no patient with certain disease severity levels or a history of substance use could ever get these life-saving drugs. And that's the problem, because when it lines up with the statutory text as well. There's the procedural restrictions that are asserted in D1A, that's the prior authorization process. And then there's the substantive restrictions, the exclusions on coverage, and it uses that word in D1B. And that's the list. That's the list of grounds on which you can exclude coverage. And Virginia did not comply with that. I would also say, the government has alleged these sweeping consequences. We won't be able to control our costs. States won't be able to use prior authorization anymore. There's been no evidence produced to support that. No amici have appeared to support that. And it's just not true. States will be free, if the court affirms the district court below, states will be free to continue to use prior authorization for the reasons that it has been recognized are proper. In the Walsh case, in Concannon, in Thompson, in all the cases in the lower courts where they recognized, sure, you can use prior authorization, but you cannot use it in a way that completely excludes a patient from coverage of a drug, no matter what the doctor says.
Can I ask, this is a side point, but maybe you can respond to this. So there was one misrepresentation that was sort of an outlier, and it had to do with one patient who was asked whether or not they could use a preferred alternative drug instead of the recommended drug. And the misrepresentation alleged was that she wasn't eligible, couldn't use it for a variety, I guess, of medical reasons. That turned out to be false. That has not, that's the allegation. That has nothing to do with the requirements, either one of the two requirements in this case, pre-authorization requirements. Why isn't that claim at least a legitimate claim?
If I may respond, I see my time is up, Your Honor. I know the patient, example patient you're talking about, Judge, but the description, the government's theory of falsity and materiality in this case, as asserted in the rest of the complaint, is laser focused on the failure to meet the fibrosis score and disease and sobriety levels. So they still assert that even in that example, the reason why that claim accrues False Claims Act liability is no patient above a certain fibrosis score and no patient with a history of substance use could get the drug. And for the reasons we've asserted, those were improper, unauthorized criteria.
Thank you, Mr. Phillips.
Thank you.
Mr. Tara, you have a few minutes.
Thank you, Your Honor, and I'll be brief. I just have 3 brief points. First, to respond to Judge Quattlebaum's point. So all 50 states and the District of Columbia have opted into the Medicaid drug rebate program, which requires them to cover covered outpatient drugs unless an express exclusion applies. And so then Congress gave separate express exclusions as different types of authority. So A1A is the prior authorization authority, and that is very broad, but it is not limitless. Your Honor mentioned—
But it's not what?
Limitless? Sorry, Your Honor. And so a state cannot impose a prior authorization condition that violates a different part of the Medicaid Act or some other federal law. And so Your Honor referenced A19 before, and that's the best interests provision. And that's the provision I suspect Walgreen would have invoked to try to invalidate Virginia's prior authorization conditions as going too far, as violating a different provision. And so the idea is a state has very broad prior authorization authority, but it can't go too far. The problem, however, is that
What's the too far? Too far, I don't know what that means. Is it arbitrary and capriciousness, or is there some statutory or regulatory description of what's too far?
Sure, it's a statutory and a regulatory provision. In the Walsh case and in the Thompson case, it involved the statutory.
Thompson's is the D.C. Circuit case?
Yes, Your Honor. It involved the provision you invoked, the best interest provision. And so Walgreen, I assume, would have argued that the care and services provided were not, quote, in the best interests of the recipient. So that's one substantive provision. The other substantive provision is from a regulation, 42 CFR 44230, which is the amount, duration, scope regulation. And that says a state can't violate the amount, duration, or scope if doing so arbitrarily denies or reduces coverage. But the core principle here, again, is that those are outside substantive conditions or limitations that apply. But A1 itself allows, clear text of the statute, states to subject any covered outpatient drug to prior authorization. And so, to Your Honor, again, to Judge Quattlebaum's point about how, well, does that render D1B superfluous? I don't think so. Exclusion, again, is a term of art. And it's also critical to point out that these were separate affirmative tools that Congress gave to states to allow for limitations on what is otherwise very broad coverage of covered outpatient drugs. I would just refer to our reply on pages 14 to 15, where the DC Circuit addressed a similar issue where, well, aren't formularies, the formulary provision, isn't that redundant or superfluous? And the DC Circuit said, no, these are separate tools, and Congress wrote the statute as it did, and we follow it. If I could just address my second point.
Very briefly.
I'll go to my third one then, Your Honor. There have been a lot of thorny, difficult statutory questions raised here today. This court could sidestep all of them if it agrees with our primary argument that Walgreen could not lie for years, collect reimbursements, and only now raise, many years after, for example, Release 172, if it actually thought that Release 172 said that these prior authorization conditions were illegal, and then challenge the validity. And so that would be one straightforward way to allow the court to dispose of the case and give the district court the opportunity to address on remand difficult questions related to damages or what is left of the case after Walgreen cannot contest the validity. Unless the court has any further questions, we ask that the judgment be reversed.
Thank you, Mr. Taro. Thank you, Mr. Mott. Thank you, Mr. Phillips. We will come down and greet counsel and proceed to the final case of the day.
Still far behind.
Okay, we'll go to the final case of the day, United States versus Red, and we are prepared to hear from you, Mr. Patel.
Good morning, Your Honors. It's good to see you. In this case, at issue is whether Maryland first-degree assault qualifies as a violent felony under the ACCA. It does not. Maryland first-degree assault is an indivisible offense with alternative means, including 1, assault with intent to cause serious physical injury, and 2, assault with a firearm. As the Board of Immigration Appeals held, one of these means, assault with a firearm, can be committed with the reckless use of force, and therefore first-degree assault categorically fails to qualify as a violent felony.
Do we need to decide the divisibility or indivisibility issue?
Your Honor, you do not technically, because even if the Shepard documents could be considered here, I think everyone agrees that they don't reveal the modality. But we asked this court to resolve it because this issue comes up all the time in Maryland, and so it would be helpful to the district court. So if I could speak to the divisibility issue, I would do that. That'd be great, Your Honor. So it's important here to first start with Mathis, Your Honors. In Mathis, the court said that the Supreme Court said that a statute is only divisible if, under state law, the jury is required to unanimously select one phrase to the exclusion of the other within a statute. Only then do we have alternative elements. The other really, really important point in Mathis, very important, the Supreme Court said that, and made this explicit, that if under state law, a charging document is not required to specify one phrase to the exclusion of the other, then we definitively know that these phrases are means because elements must be alleged in the indictment. The court said a statute may itself identify which things must be charged, and so are elements, and which need not be, and so are means. So when we apply this law here, Your Honor, there's 3 reasons why this court should find that first-degree assault is indivisible. So first, starting with the charging statute, Your Honors, 3206, that tells us everything. That statute does not require the indictment to specify the modality of first-degree assault. So in Maryland, an indictment suffices with boilerplate language that the defendant committed a first-degree assault. And, Your Honor, there's a Court of Special Appeals decision that is exactly on point and says exactly that. And that's State versus Hallahan, 121 Atlantic 3rd, 233. In that case, the defendant specifically argued that the indictment for first-degree assault was deficient because it didn't identify the modality. And the Court of Special Appeals said, no, it's sufficient because it complies with our charging statute 3206. So that in and of itself tells us that's an authoritative source. It's easy here. That tells us we have means and not elements, Your Honor. And it's telling that the government says nothing at all about this in the response brief, Your Honor. But, Your Honor, we have more than that. When we look at the pattern jury instructions, they also tell us that we have an indivisible offense here. The pattern jury instructions, which are given on a daily basis, do not require the jury to find one modality to the exclusion of the other. And, Your Honor, actually, the commentary to which the government cites is helpful to us, because in the commentary, the court says, yes, a trial court should submit a special verdict form so that a jury can identify the modality only when the defendant is charged with first-degree assault and an additional use of a firearm in connection with a felony. So the court is saying that the court doesn't always have to submit the special jury verdict, and that means it's not an element, because in Mathis, an element means something that always a jury has to identify unanimously. A modality is not chameleon-like, where sometimes it can be an element and sometimes it can be a mean. And, Your Honor, Judge Diaz, you gave us a great decision, U.S. versus Royal. That case is directly on point, too. In that case, the court found that second-degree assault was indivisible, exclusively relying on the pattern jury instructions, which, like here, did not require the jury to unanimously select one phrase, physical harm, to the exclusion of the other, offensive touching. That's not all we have. We also have even more law, Your Honor. In Dickerson versus State, the trial court did not require the jury to unanimously select one phrase to the exclusion of the other, and the Maryland Court of Special Appeals said that that was a correct statement of the law. And in Dixon, same thing. The jury was not required to unanimously select one phrase to the exclusion of the other. Now, in that case, the Court of Appeals did recommend that the trial court submit a special verdict form for the jury to identify the modality, but a recommendation means it's not an element, because again, an element is something that has to be submitted to the jury, and the jury has to unanimously select all the time. But Your Honor, also, even if you find that there's ambiguity here, we win, because that means the government has not met its burden to prove with certainty that the statute is divisible.
Mr. Patel, could I ask a question about the example you gave of a defendant charged with both first-degree assault and the use of a handgun in the
Yes.
commission of an offense? So in that case, you concede that the court could send back to the jury a special verdict sheet that would identify the particular
Yes.
modality, but that still would not necessarily make that specific conviction it still wouldn't satisfy the requirements because it's the least culpable version of the offense that we look at. Is that right?
Yes, Your Honor.
Okay.
So, absolutely. And so, and like Judge Quattlebaum said, you do not have to reach this issue. We would ask that you do reach this issue to give us guidance. This comes up all the time in district court, and so it would be helpful. But again, you do not have to decide the issue because the documents, the government, it doesn't appear that they're even saying they identify one modality versus the other, so this court would have to assume that Mr. Red was convicted of the least serious or the non-qualifying, which would be assault with a firearm. And that brings me to why the firearm means of first-degree assault fails to qualify as a violent felony. This court should follow the lead of the Board of Immigration Appeals for all the reasons noted there and even more. So, Your Honor, starting with the pattern jury instructions, they explicitly say that assault with a firearm can be committed recklessly. And this is really important, particularly in Maryland, because in Maryland, the Court of Special Appeals have said over and over and over again that trial courts are strongly encouraged to follow the pattern jury instructions because they're created by distinguished jurors who are the who's who of the Maryland bench and bar. So we can safely assume that every day, on a routine basis, juries are being instructed in Maryland that for assault with a firearm can be committed recklessly, Your Honor.
Counsel, could I stop you there? And I appreciate the law in Maryland that says that and the relevance of the instructions. So, but it seems like there's you can look at this one of two ways. One is, I would say, kind of mechanical, which is second-degree assault can be committed recklessly. First-degree assault with a firearm incorporates that. You just have to use a gun, so it's got to be in there. It's kind of a mechanical sort of thing.
Sure.
You put these two together, that's still there. The other question is whether the addition of with a firearm effectively takes away the manner in which that crime could be committed recklessly. And so assume that we're looking at it in the second way, that we got to give some qualitative analysis of the aggravator to see if it eliminates the way it could be created recklessly. How does it not do that? How can you commit first-degree assault with a firearm in a way that is reckless?
So, Your Honor, there's so many cases where this court has held that assault with a dangerous weapon can be committed recklessly. And it's very easy here, too. If somebody's mishandling a firearm, recklessly, like it's a loaded gun and just playing around with it and it misfires, that's a reckless use of a firearm. And that should be criminalized, Your Honor. I think the government wants to make Maryland a more dangerous place by saying that shouldn't be criminalized. So that happens every day. So this is not something that's unique. We're not asking the court to go out on a limb, Your Honor. And in fact, there's another case I wanted to point to. I cited to this in my brief, but I really want to talk about it in a more clear way. And that's the Marlin case, because that confirms that Maryland first-degree assault with a firearm can be committed recklessly. So in that case, Your Honor, the Court of Special Appeals held that reckless endangerment is not a lesser included of assault with a firearm, because assault with a firearm requires even a lesser mens rea than reckless.
I don't mean to cut you off, but don't the pattern and instructions say it can't be committed accidentally?
Yeah, Your Honor, but that's talking about like civil negligence. There has to be more than accidental. So there has to be gross negligence or with recklessness, Your Honor. Accidental.
Yeah, so your accidental doesn't count, but between that and intentional,
Yes.
there's conduct that you say would apply?
Yeah, so in the Court of Special Appeals decision, they said reckless endangerment requires a conscious disregard of a substantial risk of serious physical injury, but they said assault with a firearm does not. And so if you look at the pattern jury instructions, and there's also a case called State versus Frazier, that tells us that there's a lesser mens rea required for assault with a firearm. It only requires conscious disregard of a consequence to another. So it doesn't require, the consequence doesn't have to be risk of serious physical injury. So for example, if I'm just twirling a gun that's unloaded, like on my finger, right? And somebody's sitting next to me and it just happens to fly off and, tap somebody on the leg. That can't be reckless endangerment, but that can be assault with a firearm, which has a lesser mens rea than even reckless endangerment. And Your Honor, it's not only Marlin versus State. We also have the Williams decision. It's a Court of Appeals decision in which the jury was explicitly instructed that the firearm assault could be committed recklessly. And the Maryland Court of Appeals said that's a correct statement of the law. We have State versus Watts, another decision by the Court of Special Appeals where the jury was instructed the same, and the court approvingly cited to those jury instructions. Your Honor, the BIA also cites to Holmes and Middleton, which even further confirm that assault with a firearm doesn't require the additional specific intent to cause serious physical injury. So, Your Honor, for all these reasons, we ask that you find that Maryland assault with a firearm can be committed recklessly and therefore fails to qualify as a violent felony. If the court doesn't have any further questions, then I'll rest for now. Thank you.
Thank you, Mr. Patel. We will hear from Mr. Pronounce your name again, Medinger?
It's Medinger, Your Honor. So, good afternoon, Your Honors. Jason Medinger on behalf of the United States. Your Honors, first-degree assault is a violent felony under the ACCA. It does require an intentional mens rea. It can't be committed recklessly, and it does require violent physical force. I'd like to start with the issue of divisibility. To your question, Judge Quattlebaum, I actually agree with my colleague. I don't think you have to decide it here, but you certainly could. And if you did, it's very clear under Maryland law that this is a divisible statute. Everything about it screams divisibility. You have separate sections. They're in the disjunctive. Maryland case law Dickinson versus State said the use of the firearm was itself a legal element. And we have to look at Discamps. Discamps says divisibility rides on elements. And here the jury has to find, did this individual have a gun to reach the B2 varietal? The other thing that Maryland law says, this is Dixon versus State, that the assault statute is a multi-purpose statute, and it goes on to explain exactly what that means. It says when we have a multi-purpose statute, we have to treat all of the subdivisions as essentially separate offenses. That is right from Maryland law.
And I appreciate that. There's a recent case, State versus Wright or Wright versus State, that I thought, kind of, was supportive of the government's position there, but, you know, your colleague has these cases where, you know, they cite the pattern jury instructions, which don't require specification, talks about the charging documents. I mean, yeah, those two things, it's hard for me to tell. It seems like there's stuff both ways on that. I mean, what about those cases?
Right, so I think where he's wrong is he's confusing special verdicts with elements. And whether you send special verdicts or not, I think is immaterial to this process. What elements are they charged with? And if you look at, you know, a lot of times, the instructions will include a number of varietals in terms of how this crime can be committed, but the jury does have a unanimity requirement. They don't have to fill out a special verdict form in every case, even though the Supreme Court of Maryland said you should. But in my view, when the Maryland Court of Appeals says this is an element, we have to believe them. And they said it expressly in Dickerson, this is an element. And I think that's where the analysis stops. But even if we get past
Do the jurors have to agree unanimously on what that modality is?
So, Your Honor, there is, as I understand it, in Maryland pattern jury instructions that there does have to be a unanimity requirement. But again, there's no special verdict requirement, and that's the teasing out that I would do of the difference that we're talking about here.
Did you say there has to be unanimity on the different way you commit it, or that there was a violation of the overall statute?
The latter, Your Honor.
Yeah.
So,
Well, how does that help you, though? I don't understand.
Well, it helps us, Your Honor. Again, my focus of my argument is what does Maryland law say? And they're saying the firearm or the intentional causing of serious physical injury is an element, and the jury has to find it. And it makes, I think, some logical sense in the sense that, you know, when you're talking about the firearm modality, it's different than the serious injury modality. And so we need a jury to find that as a matter of fact. Did the person have a gun or did they not? And as we talked about in a couple cases with my colleague, that actually matters when you have these other crimes where you have the use of a handgun. That becomes an element because you could be, you know, convicted of one but not of another, and is one a lesser included or not? So I think really my argument is on Discamp's what is or isn't an element, and I think Maryland law is clear that it is. But as we said,
Well, let me just follow up, and I'm sorry to get stuck on this, and I want to make sure you have time on your other issues, but I'm struggling with, I get the cases that Dickerson and another one that talks about an element, but if you're charged with violation of, you know, assault in the first degree under Maryland section, you know, 3-202, and the jury returns a verdict that says we're unanimous.
where he pistol whipped the man, that could probably be both. It could be B1
Sure.
or B2.
Right.
Because he used a firearm, but he certainly caused serious physical injury. I think in that instance, when the government puts on evidence that a firearm is involved, the jury gets the instruction as to B1 and as to B2.
But the whole point of
And they don't reach a special verdict.
The whole point of this, no, I'm sorry to interrupt you, but the whole point of the categorical analysis is that you don't look to what the defendant did. I grant you, he pistol whipped somebody, but we're now deciding whether or not that offense at its least culpable level amounts to a violent felony for purposes of the ACCA. That's an entirely different analysis.
Right, and I'm not quarreling with you at all on that, Your Honor. We do look at it categorically. Again, I'm just trying to take Maryland law. They say it's an element. I think we should respect that, and that's where it's.
but the question is, if it's categorical, then we look to the least one in there. We don't look as to what he actually did.
That's accurate, Your Honor.
So, again, how does that help?
Well, again, it helps. It helps me, Your Honor, because on the divisibility analysis, if we have to figure out are these elements or are they means, my point is Maryland Court of Appeals has told us they're elements. And that's I think, dispositive of the issue. Under Aparicio Soraya, we have to look at what does the Maryland courts say about it.
So but we have no means of knowing the modality that was here, I take it. Nothing in the documents show that.
In these cases?
Yeah, in this case.
I'll concede we do not, Your Honor. Again, the 1996 assault could be either. The one in 2000 where he committed the assault in prison, that's under a different statute. If you look at it categorically, I would say there is no ability to say which modality it was. The statute doesn't say. Granted, you're not supposed to have firearms in prison, but I'm not going to go there. Categorically, A6 doesn't really speak to that. But as Judge Quattlebaum might have suggested, it could be all academic if this court finds B2 does satisfy the ACCA requirements too. And here again, I would rely very much on Maryland state law. And we have two opinions from the highest court in Maryland, which is now the Supreme Court of Maryland. We have the Hale case and we have the Dixon case. And they say expressly, first-degree assault is a specific intent crime. Full stop.
Hale and which one?
Dixon, Your Honor.
Okay.
That's also repeated in two intermediate appellate court decisions. That's Chilcote and Williams, and they also say exactly the same thing. Maryland first-degree assault.
But Hale and Chilcote were talking about B1, weren't they?
So, Your Honor, I don't believe they were. And this might be a point of contention between myself and my colleague, but they didn't say only B1 is a specific intent crime. They did not. They said first-degree assault is a specific crime, period.
But maybe, you probably know the cases, I'm sure, better than me, but when I looked at those, we looked at them, it seemed like that language may be there, but when you look at the case as a whole, it's talking about B1. And the one that wasn't was Williams, which was, seemed to be talking about B2, but it was unpublished. And so I may be wrong on that. I mean, if you think, if Hale is not a B1 case, I'm certainly interested in that, but I read it to be a B1 case.
Right, and I guess, Your Honor, my point is, and what we're trying to glean from is we're trying to look to state law, we're trying to respect state law, and this is what they've said unequivocally, first-degree assault is specific intent. I agree with you that they didn't, there is no case, none of us, myself or my colleague over here, has a case which expressly says B2 is a specific intent crime. We don't have that, but we have to look to what the Maryland Court of Appeals did say, and it did say it's a specific intent crime. The other thing that I'll sort of transition.
You were saying at least from henceforth from that, you would never charge anyone under B2 unless it was a specific intent proved.
It's accurate, Your Honor, because again, if we're going to do that, if we have
Anybody who's been convicted under might have them a habeas petition somewhere hanging out there.
Well,
on a lesser level of intent.
Well,
I just say they might, because you just said they could not be convicted under it.
I think that's the most accurate statement of the law, Your Honor, and I'm just trying to get it right. I'm not worried about habeas petitions. My view of the best and most accurate statement of Maryland law is that first-degree assault is a specific intent crime because none of the other statutes make sense if you go to where the defense wants you to go. There's no room for second-degree assault under their theory. There's no room for reckless endangerment. They all just kind of jumble together. And you can have prosecutors making the decision, I'm going to charge this reckless crime for first-degree assault and really ring the bell on a higher statutory maximum for conduct that really is reckless and should be down the rung.
When it said that, I grant you, they didn't say they were only talking about B1, but the modality at issue in the case was B1, right?
I think that's accurate, Your Honor. But that brings me to my next point, which is a great transition. We talked about the Maryland Court of Appeals decisions, Hale and Dixon. There are two Maryland intermediate Court of Appeals decisions that do specifically talk about B2, and those are Jenkins and Jones. And now, both of those opinions, after they came out, were later vacated by the Maryland Court of Appeals on other grounds. But those said expressly that when you have a B2 varietal, the use of a firearm is something that we get specific intent from.
Vacating meaning, vacate is an interesting word. When you vacate something, it never happened. So you're saying vacate it except for that part?
No, Your Honor. So they vacated that opinion, and so to your gone. But the question is it nothing?
Go back and look at it because there's something in it that we ought to preserve.
Correct.
That doesn't seem to follow too well.
Well, I think, Your Honor, we're looking for statements of, and this court is struggling with, what is B2? Is B2 specific intent? And we have to look to Maryland. And so the only thing that any,
Problem with that, I'm just having a problem with the use of the term vacated. When you vacate something as opposed to reverse, it's a jurisdictional thing. You vacate it, it's gone. It's like when you bring something on bonk to this court here, you got an underlying opinion there, it's vacated, gone. Then we don't typically like to be hearing arguments about something that doesn't exist. Even if it has something nice in it you like to bring up. What you're saying is, it's almost like having, well, these judges had that opinion. We like them to come and give their opinion on a matter that was no longer in controversy. So that's not a good taste, but proceed if you
It's
want.
gone but not forgotten.
well, right, and I guess, Your Honor, so the question is then, I mean, what do we have? And I'll say, as an advocate, this is what we have. We have a statement from a Maryland Court of Appeals speaking to the very issue that we're trying to consider here, and my argument is it's not nothing. It's not zero. They had somebody look at B2, and they said B2 evinces a specific intent because we can infer specific intent through the use of the firearm. And obviously, we've cited a bunch of other cases that say that too, generally in Maryland law. And so I guess that's our point. If we're trying to respect what the states have said, we can't just bury our heads in the sand and assume that Jenkins and Jones just never existed and that we'll just pretend that they didn't
The two
happen.
cases that were vacated.
Yes,
We can't assume they never existed when they vacated them.
because they are accurate statements of Maryland law. That's
Vacated them. They should have left them on the books. They could have said vacated except for such and such, or, in part. I don't want to beat it to death, but I mean, when you say you can't assume they didn't do it, when vacate, that's the meaning of the word.
Can I move a little further down in a couple areas that I think help this decision and help us get a little closer?
Before you do that, just so I understand your position, are you saying that a defendant in Maryland can't be convicted of recklessly firing, using a firearm to assault somebody? That's not a first-degree assault under Maryland?
It's not a first-degree assault. That would be a second-degree assault or reckless endangerment.
And there's no case that you know of that has actually upheld a conviction under those facts where someone, for example, fires a weapon into what he or she thinks is an unoccupied apartment or a house or something like that and ends up injuring somebody. That's I would think, pretty reckless. Under Maryland, that's not a first-degree assault.
Right, so the case that I think you're thinking of, Your Honor, is actually Snyder versus State. Those were first-degree assault and second-degree assault. And I just read it very recently. But I'll say what they said there is that the jury could have inferred from the act of shooting multiple rounds that they intended to cause immediate physical harm. So in my view, if you read Snyder versus State, they're reading the same kind of specific intent that I'm talking about. And that is a use of a firearm. It's shooting into an unoccupied house. I think there's intent there. I know you said it's reckless. It's that too, but it's more than that. And I think the case in Snyder said what we're saying, that it's a specific intent crime. The other
Reckless, if you said reckless, it would reduce it to a second degree.
correct.
But you got facts that support both, and you think that without specifying which one a jury would find, you just find them guilty under the greater one.
Well, Your Honor, I guess it all depends on how it's charged, but in Snyder, if memory serves, it was a first-degree assault conviction, if memory serves. But the other points that we have here, and again, I think we're all just trying to get it right and see what Maryland first-degree assault is. The Maryland legislature has deemed it to be a crime of violence, and I know in the United States versus Battle case, this court found that to be, quote, strong evidence of the fact that this also should be considered a specific intent crime. Battle was about a predecessor to this crime. It was assault with intent to murder. That assault with intent to murder later went into this statute that we're talking about here. The other thing that we have is we certainly have a number of other decisions that talked about this issue. United States versus Height from the D.C. Circuit.
Were any of those post-Borden?
No. No, Your Honor. We also, would suggest to the court that the way to not do violence to the Maryland statutory scheme is to rule for the government here. Again, it's hard to look at that statute and put a reckless mens rea into the first-degree assault statute, because it just then is dissonant with what second-degree and reckless endangerment should be. The last thing I'll mention is, even if this court had some belief that there is some recklessness there, we would still stand on the argument that it's extreme recklessness, because you have to have some daylight between, again, second-degree assault and first-degree assault. If it's recklessness, you're going to have extreme recklessness under the first-degree assault varietal, and that's United States versus Manley. This court looked at the Virginia aggravated assault statute and found, even if there's some debate about whether recklessness applies, it's an extreme recklessness. And I think that would be indicated here.
What, Counsel, just looking at the statute, if the what subsection D, I've lost them. Oh, here it is. The B1 obviously expressly uses intentionally. B3, which came later, does too. 2 doesn't. I know you made the argument that that the fact that those two provisions use it suggests it must apply to 2. The flip side of that is they knew how to put those words in there and they didn't. And I guess I'm trying to I'm just trying that from just reading the statute standpoint, it seems odd to me that you got intentionally expressly in 1 and 3 and not in 2, and we, don't make something of that.
Your Honor, I'm really glad you asked that question, because it gives me the chance to say what I'm about to say, and that is, we have to assume that the Maryland legislature knew what the law was when it was recodifying B1, B2, B3. They knew what the law was, and what they knew was that in Maryland, the use of a firearm is a specific intent crime. We infer specific intent simply by the use of that firearm, so therefore we as a legislature, we don't have to put intentional in there. Everybody knows Hale, Dixon, all these other cases, first-degree assault is a specific intent crime. We don't have to go back and put that in there. I take Your Honor's point that it's not there, but again, we have to presume that Maryland knows what it's doing and didn't sort of accidentally put a reckless crime amidst 2 other intentional ones. It just doesn't make sense. So that's my argument, Your Honor. I'm a little over my time. Unless there's any further questions, I'll rest.
Thank you, Mr. Mettinger.
Thank you, Your Honor.
Mr. Patel, you got a...
Thank you. Just a few points. So on divisibility, addressing the government's argument that sometimes the courts refer to the modalities as elements or separate offenses. That doesn't matter here, Your Honor, because from the birth of the categorical approach, we know that state labels don't matter. What we give deference to is the substance of state law, and the substance of the state law tells us that the jury is not unanimously required to select one phrase to the exclusion of the other, and that the indictment does not have to specify the modality. There's a case that I want to point the court to on that point. It's a Fifth Circuit case, U.S. versus Herald, where the Fifth Circuit, the conservative Fifth Circuit, found that a Texas statute was indivisible, even though Texas courts had referred to the alternative phrases as elements, because in substance they were means. Because when you looked at the case law like we have here, it was clear that the jury wasn't unanimously required to select one phrase to the other. So what the court said that was helpful there is that sometimes states imprecisely refer to means as elements, and so that's what we have going on here. But what we have to give deference to is the substantive state law. So the other thing, Your Honor, I wanted to point out is The government is absolutely wrong about Hale versus State, Dixon versus State, and Chilcote versus State. Frankly, it's a sleight of hand. When you read those cases, they expressly refer to the injury modality, not to the use of firearm modality. Even in the unpublished case, Judge Quattlebaum Williams, there's a parenthetical that refers to Marlin when it's talking about the injury modality. So it is just, it's really absolutely wrong for the government. It's misleading to say that those cases were about assault with a firearm. They absolutely were not. And then Snyder versus State, again, the government's misleading on that case. In that case, the defendant, the issue was whether the first-degree assault was accomplished by an attempted battery version of second-degree assault. Yes, attempted battery does require an intent to inflict force, an intent to inflict force. But that's not what we're talking about here. The version of second-degree assault that makes use of a firearm reckless is the battery version, and that can be committed recklessly. So again, the government is mischaracterizing Snyder versus State. The government says that because Maryland calls assault with a firearm a crime of violence, we should too. U.S. versus Proctor rejected that specific argument. Whether or not something qualifies as a crime of violence is determined by the federal definition. And so if under the federal definition it's not a crime of violence, who cares what the state labels it? And then one last point I wanted to make, Your Honors, is that the government's argument would actually render assault with a firearm superfluous if it required the same intent as the injury modality, as the government says it does. Then what would have been the point of even putting the assault with a firearm prong into the statute? The legislature would have had no reason to do that because it would have been subsumed under the first prong.
Would that same argument apply to B3?
Yeah, I mean, there you have strangulation, Your Honor.
I mean, you could make the same thing, that's superfluous too. And you know, it presumes all legislatures act with perfect consistency.
Right, and Your Honor, beyond that too, like sometimes there is some overlap. We do have the case law, we do have the pattern jury instructions that confirm our point. So thank you, Your Honors.
Thank you, Mr. Patel. Thank you, Mr. Mettinger. We'll come down and greet counsel, and the court will adjourn until tomorrow morning.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.